All right, what you're going to hear is this is a hearing in Canada. One of the members of the common law conversation group. What you're about to hear is a kangaroo court. This is what you call a kangaroo court. And the gentleman's name is Brad. He did actually did a really good job. I'm not. This is not a criticism of Brad at all. Or no, basically, I mean, he did a phenomenal job. I just want to hit some points where uh, he could learn for the next time, because what he did right now is phenomenal. I mean, here's a guy. He's got no legal education. He's not a lawyer, and he's got the attorney tripped up. He's got the judge tripped up, and guess what? You polish him up a little bit. Hopefully, this will do this. This little video, polish him up a little bit. He's going to be dangerous because these people are these are petty Fagershyster attorneys and judges. They are as corrupt can be. All right, so as far as these hearings go, this is a phone hearing. You know, it's bad enough they're doing Zoom hearings, but this is a phone hearing. Now, you know how bad phone hearings are? I mean, it's bad enough you're doing a Zoom hearing, but a phone hearing, here's what happens. How do you know when you raise a question that there's not somebody feeding them the answer in their ear or typing something on a chat screen that you can't see giving them the answer? I mean, that's why you go to open public court, so that when you get somebody up on the witness stand and you got them pegged, you get them in a corner, there's nobody can help them. If they don't know what they're doing or they can't speak, there's nobody there that can help them. So, don't do these Zoom hearings and don't do these phone hearings. And especially, listen, even in this hearing, Brad got muted at a certain point. You know what? I'm not in any hearing where they could just mute me. Because no, I mean, there's no due process with that. Because what they do is they mute you, and they let the attorney, who's got no personal knowledge of anything, speak, and the judge and the attorney are having a conversation. Two people with no personal knowledge of a matter are having a conversation, and you're muted, so you can't even object. So they may mute you for 2 minutes, and you're missing all kinds of objections, because for anything to be appealed, you've got to object to it. Well, how can you object to something when you're muted? This is why you don't do these hearings. Don't do these hearings. But let's jump into the call, and we'll have some fun with it. What's cool is this is the group actually listening to Brad's call, and they're chiming in, and they did a great job too. They hit a lot of stuff, but there's just a couple things that jumped out at me right away, obvious things, and they were right there on the edge. They just missed a couple key things. They could have shut this hearing down in a blink of an eye. And like the Northern Ireland, when they asked that attorney for like 4 questions, that prosecutor ran. And you could do the same thing here, but I mean, he did a phenomenal job. And what's funny about it, listen, I'm hearing a lot of my language in here. Probable cause, no personal knowledge, and listen, this is the stuff that really trips them up, man. But let's give this a quick listen, and you're going to hear the group also. They're going to critique it. But like I said, this is not a criticism. Brad, I think, did a phenomenal job. But I think we could have some fun with this.
Homemade moonshine, anyone, while we're watching?
Oh,
Here it is.
Mr. Kerrigan?
it's Brad Kerrigan, Bradley Clayton Kerrigan. Yes, that's who I am. How are you today?
All right.
Well, even if you want to have fun with that, everyone's hung up on the name. Instead of giving them your name, they say, Mr. Kerrigan, say, no, that's not my name. And just sit there and wait and see what the judge says. That's not my name. And don't offer your name. Just say, that's not my name. And she'll say, well, what's your name? Then you could say, my name's Alphonse. That's my Christian name is Alphonse. And she says, is this Alphonse Fagiola? I say, well, Fagiola is my surname, but my Christian name's Alphonse. You could refer to me as Alphonse. So you sort of you're not, because here's what they're doing with this dumb trust stuff is you're not in court. You don't know what that judge is looking at. I guarantee that judge is looking at your name in all capital letters. Okay, so if they say, is this Alphonse Fagiola, I would say also, listen, what are you looking at, sir or madam? I need to look at what you're looking at to see if that's my name. And if they bring me something in all caps name, I'm going to say, No, this looks like a nom de gore. That's a resemblance of my name because the only names I've ever seen in capital letters, it's either a corporation's name or it's a trust, and I'm neither. I'm not a trust or I'm not a corporation. So that's not my name. My Christian name's Alphonse, and my surname is Fagiola, and that's it. That's how I'm moving. As far as what you're going to hear, also, the only thing that it maybe cringed that what Brad did is don't call them Your Honor. There's nothing honorable about these people. Don't put these men and women on a pedestal above you. They're not above you. They're below you. These are public servants below you. You don't call them honor, my honor. So don't do that. I call them by their first name. Hey John, hey Mary. Now they're gonna quip about that. I don't really care. What do you want me to call you? You know, I'm not gonna call you Your Honor. Sorry, no. The only honor, my honor I have is my Creator, and that's not you. So if your first name's John or Mary, that's what I'm going to call you, John or Mary. Now you want to call me, hey, if you want to make it easy on yourself without getting to that, just call them sir or madam. That's what I do. Hey, sir, hey, madam. That's it. That's just a casual reference to somebody. It doesn't grant them any kind of nobility by calling them Your Honor. That's why they do that stuff. They're trying to lower your status, you know, because you don't walk up to your friend on the street and say, Your Honor, John, you know, Your Honor, Fred. No, you're on not only you're not on the same level as this judge, you're above this judge. So don't give them any kind of title or any kind of recognition. Let's go on here.
Fine, thank you, sir. I'm looking at.
Are we on record now, please? Are we on court record?
Yes, sir.
Okay. Well, I reserve all my rights, and I waive no rights ever. I am.
That's me. I know you got. That's great. That's the first thing you want to do. And what you also could have thrown in there from the start. I'm here by special appearance. Because what special appearance is, if you show up to a hearing and you don't specify, they're going to take that as general. That's a general appearance. A general appearance means that you've granted the court jurisdiction, but they don't tell you that. They're not going to tell you this. But when you show up and say, yeah, I'm making a special appearance today just to challenge jurisdiction, that means I'm in this court because I got business to take care of here. I got to take care of this jurisdiction matter here. But I'm not granting you guys jurisdiction in this matter. I'm here to discuss that matter. That's when you say I'm here by special appearance. That's the purpose of that. But he did real good there. He said, I reserve all my rights. I waive no rights ever. Now, I don't know Canada's constitution, but I know in the states over here, both in the state and federal constitutions, you have a right to a trial by jury in all matters. Doesn't matter whether it's a traffic ticket, doesn't matter whether it's a mass citation. In all matters, you have a right to a trial by jury. So if Canada has that, you smack them in the face with that. When you hear a certain part with the judge will come up and say, well, at this level of court, we don't have trials by jury. Well, then I must be in the wrong court. If you have that, basically, if that's secured, that they have to follow that in the Canadian Constitution, and you stick it right at them, basically. So, but he did real good here.
The beneficiary of the court today. Does the court have any evidence I am not the beneficiary?
The beneficiary stuff, listen, I know Richard did that in his hearing, and I'm going to tell you guys, please stay away from that stuff. Don't get into that. Don't say I'm the beneficiary. Guess what says you're the beneficiary? Your affidavit of status. When you do that affidavit of status, you're stating, I am man, basically. You know, you're telling them, I am man, Alfonso Nicholas Fagiola. You know, my rights come from my Creator. Your affidavit of status enshrines you as the beneficiary. In other words, you never have to let the words leave your mouth. You're the beneficiary just by that affidavit of status. You're the beneficiary. So don't. I cringe when people do this. Don't talk about trust law before these people. You don't need it to beat them. Okay. Like I said, I talked to Steve Emerson. Steve Emerson's a guy who's won over $40 million in settlements. Not once did Steve use a birth certificate or did he use trust law. Okay, he just used with the basics. I mean, you hang them up on their own words. And a lot of what I do, it's funny, people think everything I do is common law, but I'm actually doing a lot of commercial law stuff. But if you really watch what I'm doing, I'm never addressing their matter that's coming at me. It's always, I'm addressing their process. I'm always attacking their process. Hey, there's nobody here with personal jurisdiction in this matter. There's no witnesses here. these are requirements you have to have for any kind of hearing, or you're in a kangaroo court. If you're in a court where there's no witnesses and there's no evidence, you're in a kangaroo court. You can't get a fair trial there. But so just stay away from the trust law stuff, please.
I don't know what you mean, sir.
Then therefore, I am the beneficiary of the court, and I hereby appoint this court as the trustee to settle this matter, so we can move forward.
All right. I have two
Now he could prove it,
information
so
in front of me.
You have affidavit of status?
Yeah, I don't. Before I hear anything further from you, Mr. Kerrigan, I'm wondering if I can hear from the Crown as to what.
If I could hear from the Crown, who the heck is the Crown? Is the Crown going to talk? Is that Mr. and Mrs. Crown that's going to show up to talk here? Don't let them do this to you when you're in these hearings. When they say, I got to hear from the Sewer Authority, I got to hear from the Crown. No. Excuse me, objection. Who is the Crown? The Crown don't talk. You're going to bring up a crown, a gold crown, and put it on the table, and it's going to have a conversation with us? Who the heck is the Crown? No, you give me a name. Excuse me, who's claiming to represent the Crown? I need that man or woman's name. And oh, by the way, Miss Pettifogger Judge, I'm going to need that man or woman's bar number also. I need their bar number here, because I'm going to have some matters with this prosecutor, this attorney that's trying to move this matter. So I need the name and I need the bar number. But let's move on here.
Where we stand and what the next step is from her point of view.
Well, I would object to that unless she has...
Mr. Kerrigan,
It sounds like the judge asking the prosecutor what the next step is. Wait a minute. The prosecutor, we don't even know who the name of the prosecutor is. She's got no jurisdiction in the matter, no authority in the matter, no legal standing, and no personal knowledge of anything. Yet the judge is talking to the attorney to find out how they should move this case. You got two parties talking, the judge and the prosecutor, that have no personal knowledge of anything, and they're going to move this action against Brad. This is all hearsay. It's not only hearsay, it's criminal fraud what they're doing, because they're trying to extract money away from Brad. They're trying to steal from Brad and this is what you call, and you'll hear Richard comment on it later and some other people, this is called a simulation of legal process. Okay, this is not a legal process Brad's in. This is a kangaroo court process. Okay, this is administrative court junk. Okay, this is not a legal process he's in. So yeah, just keep that in mind, that don't let these pettifogger shysters open up their mouth. If you got somebody in there with no personal knowledge, and Brad does a good job coming up, you will hear him say, I'm going to need her under oath. 'Cause you can't let these attorneys talk against you, because here's what's happening. Brad's in a hearing with somebody who's the Crown, who we don't know a name, who this person is, who this Crown is. We don't know a name. And this person's claiming they're speaking for this Crown, and they're taking actions for the Crown. It's literally like somebody coming in and saying they're speaking for Mickey Mouse or Donald Duck. I mean, they're going to speak and act for Mickey Mouse or Donald Duck. When the Crown's no different than Mickey Mouse or Donald Duck. The Crown doesn't exist unless Mr. or Mrs. Crown come into this hearing. This is all fraud. That's a fiction. There is no Crown. All there is an attorney that's trying to commit fraud against you and claiming they're going to speak for Mickey Mouse or Donald Duck. But let's move on.
it's not your turn to talk, sir, and I want to hear from the Crown regarding where we are. Not you. I'll call on you in a moment.
Yes, but I do have the right to object, Your Honor.
And bang, I'm glad Brad said that. Listen, in order to preserve matters for appeals, you got to object to them. So if you're ever in a hearing and something comes up, don't let it slide by. Object to it. Even if you don't know why you're objecting to it, it just sounds wrong to you, object to it. And there's, maybe I'll do a video on that too, how the standard objections in court. And really, you only need about 3 or 4 of them you're going to use. You'll use them over and over again. But even if you don't understand why you're objecting, get the objection on record. Objection. What's the base of your objection? This doesn't sound right to me. This doesn't sound lawful to me. So even though you might not have the right reason you're objecting, you still got the objection on the record that you could reference if you take this to an appeal court. But hopefully when you move through this paperwork, the stuff we do here, they're not going to want you. They're not going to want to have another hearing with you. Put it that way. That's our hope. But let's move forward. But the funny thing too is with his affidavit of status, it seems nobody had his affidavit of status. I think that's how they started out, and then you're going to hear something later that's hilarious, because the prosecutor actually states she references something on Brad's affidavit of status that she earlier said she didn't have. So now she committed perjury on the record, recorded perjury. You either have something or you don't. Come on. All right, let's move on.
I'd like to hear from the Crown as to what the next step is.
Right. So these matters started February 22nd in the CMO.
Objection. That's the attorney talking. She's got no personal knowledge of anything. So she's trying to put facts on the record that she's not qualified to put on the record, because she's not a qualified witness. A witness in all matters must have personal knowledge of the matters. Personal knowledge is not the cop told you this or you seen it on a ticket. It's that you witnessed it firsthand. You seen it with your own eyes. She don't have personal knowledge, but she's over here talking about things that she doesn't know about. This is ridiculous. Don't let attorneys do this to you. Objection. And over here it's Rule 602, both state and federal. Most states are Rule 602. The federal 602, but it states that a witness must have personal knowledge of a matter before they can testify to it. So what you have is an attorney testifying against Brad that's not under oath, which that I would have recommended. As soon as his attorney opened up her mouth, he should have said objection. Listen, this whole proceeding, she's going to have to be put under oath first, so that everything she says is on the court record, and that she's under the penalties of perjury for whatever comes out of her mouth. Do not let these petty Fager-Shyster attorneys talk against you. Let's move forward here.
They reported to court on the last occasion.
Can you
Mr.
pause
Kerrigan
that?
appeared and was disputing the disclosure that he had received.
You can object to the judge too, man. You did good so far, but and I'm not like dogging you or anything, but you can object.
Just tell
to the
me.
judge
I don't
too.
mind.
Okay, cool. You can object to the judge when she said, "I want to hear from the Crown on this matter." Objection. Who's the Crown?
Boy, that's a guy who's trained really well. Yeah, he's got it. Objection. Who's the Crown? Is that Mr. and Mrs. Crown we're dealing with here? Because this is what they're doing to you, and they're doing to all of us in these cases. The people fell asleep on their rights, okay? They got indoctrinated, they got dumbed down, they got intimidated, and they forgot who they were. And because they got dumbed down, they let this most evil society ever created, the legal society, they let them take over their courts and even the government that's supposed to be the government, which is our corporations. But they let the legal society, the bar association, take over the courts. And look what they did to you. They told you, you get in trouble in any matter, first thing you do is you get an attorney. And when Richard, in his case, when he had his case, Richard filed affidavit of status into the matter, and he was kicking their butt. With the affidavits, he filed the affidavit of status and affidavit of fact, and he was kicking their butt. So what they had to try and do with Richard was they can't answer his affidavits, and they know they can't answer his affidavits. So the dirty little secret was, let's try and get one of our petty Fager-Shyster attorneys attached to Richard, because if they can attach an attorney to Richard, then Richard's got to speak through the attorney, which puts Richard under the court, puts him under the judge. So that was just basically a way to try and lower Richard's status. And the way they did it, they said he's not mentally competent to he don't understand the process. He don't know what he's doing. No, he knows enough to serve a couple affidavits into the matter and shut you people up right away. So Richard knew exactly what was going on. So their little ploy was, let's get Richard, let's call Richard incompetent, and we need to have a hearing to prove Richard's incompetent, so we can attach one of our petty Fager-Shyster attorneys to Richard, so that we can get jurisdiction over Richard and control Richard. Because if Richard's working with affidavits and Richard's on his own here, they have no control over Richard. But if they can attach the attorney to Richard, they got control over Richard. And the judge in the hearing he would go to, the next hearing, would state that, Richard, you got to speak through the attorney's got to speak for you. And that's the purpose of this ridiculous thing they do with people when they say you're not mentally competent. No, I'm very competent. So this is what they're doing with that.
Where's Mr. or Mrs. Crown? Who is the man? Who is the woman bringing forth this matter here today? Who is it? What? Who is the Crown? I don't know who the Crown is, Your Honor.
The Crown?
And I wanted to point out at the beginning that you said your whole name, upper and lower. I mean, you just read out your first, middle, and last, and without saying from the family of or something like that. You gave them, you almost got it. We'll see how you do, but you don't want to give them jurisdiction over there by giving the whole name that they asked for. You should have just said Brad. My friends call me Brad. I don't know.
Yeah. Or you could, I'm the king. You said, no, that's not my name. You can call me the king, the beneficiary, the man, whatever. There are many titles, like quote unquote titles.
And they're all right there. All those comments are right. Basically, you want to give them any name that's different than the one they have on that piece of paper. So if they have Alfonso Nicholas Fagioli on that paper, I'm going to state that, listen, my name's Alfonso, or you could just call me the beneficiary in this matter. Or you could call me the secured party. I'm the responsible party, or you could state this. You can call me the holder in due course, because holder in due course is sort of secret language. Think about it that way, because they are working under this little corrupt trust system behind you, that you're not supposed to be aware of. But if you come out and say, well, I'm the responsible party and holder in due course of this account, well, I didn't have to state anything about trust law. I'm just talking about basic. I mean, you go look up responsible party and holder in due course, what it is. And basically you're stating that, listen, anything attached to your name is yours, is your property. Your body, your information, your genetic material, anything you claim and anything you own is yours. You can't do crazy stuff like go claim a city block or something, but you know what I'm talking about, like your car, your home, your house, your land, anything you claim within reason that you could prove, basically. So, you just got to keep that in mind, that the title thing, just try and give them a name that's different than what they have on that paper, because they want you to say, just like they taught you in school, they all brainwashed us. First thing we were taught in school was, when your name's called, raise your hand. What do you think that's for? Listen, they were lining you up for this kind of stuff. That basically, when your name's called, you answer to your name. So that when you're in these court proceedings, people say, they'll say, John Smith, and John Smith will say, yep, that's me. Hand raise, that's me. And what that court just did, it's something called joinder. All right? They have this trust name in front of them that they're not going to show you. It's all caps. Which, listen, I don't care if they put my name in, they write it in flowers. Or it's all caps, or it's lower caps. Doesn't matter. That really doesn't give them any authority. But what these dirtballs are doing, this judge, they're looking at this all caps name up there and treating it as a trust. And when they ask you, are you Alfonso Nicholas Fagioli? If I were to say yes, they're going to claim that basically I agreed to be the trustee for the beneficiary of that name that's up there, the all caps name, and they're going to try and claim that that gives them jurisdiction. They're not going to tell you that. They're never going to say that to you in court. No one's ever going to walk in with a birth certificate. They're not going to come in with a birth certificate and say, we have jurisdiction over Mr. Fagioli. We got his birth certificate. It's never going to happen, okay? So they're right. Listen, you just try and give me, even if you want to say, like, my name's Alfonso Nicholas of the Fagioli family. Because remember, my real name and your real name is really your you want to call it, I don't want to get religious, but if you want to call it your Christian name, my Christian name would be Alfonso Nicholas. Now, my name is not Fagiola. That's my family name. There might be 100 Fagiolas. So Fagiola is one of many, but I don't know any Alfonso Nicholases. In my family, so I would identify myself as Alfonso Nicholas in any formal matter. But that's a good way to say it, is I'm Alfonso Nicholas of the Fagioli family, because that's not what is written on that paper before that judge. And he can try and see what he says. He could try and call you on it, and just stand your ground. No, my name's Alfonso Nicholas of the Fagioli family. Sir, if you're having trouble with that, you could just refer to me as the holder in due course in this matter. In other words, what you just told him by stating hold on due course is, you know that little trust game you're trying to play? You want to try and hide from me? Guess who owns that trust? That's me. I own that. When I told you I'm the holder in due course, I just claimed the trust. I didn't have to say I'm the beneficiary. I didn't have to get in any trust law stuff. I just had to throw one little phrase out at him. Yeah, sir, you could call me the holder in due course. That's it. You know, you stick to your ground. They don't get to call you what they want to call you. All right. They have to call you what you told them to call you. But basically, now you can't get crazy, you know. But don't let them just skate through by just raising your hand like you were like a good little kid in school and say, "Yep, that's me. I'm Alfonso Nicholas Fagioli. Yep, I'm that. So what you're saying is, yep, I'm that trust. You're here. You guys can go railroad me now." So don't do that with these people. You know, make them work for everything. Never cede any ground to these people. But let's move on.
I know
You're,
correct verbiage, but
you're
you guys,
by now referred to as you can make it up.
yeah,
You
you
also,
King of the court.
you can say you're Squidward. Like it doesn't, it doesn't matter, because that's not your name, and you don't
say something. Sorry,
Go ahead.
I did say something like that in I think it was this is the third time they've tried to get me to set a court date and I haven't agreed. But I did state that my name was Brad from the family Kerrigan before, and then the judge said, well, I'm just calling you Brad Kerrigan, or I'm calling you Mr. Kerrigan. I says, no, well, I think it's even in this one. I can't quite remember.
Now, Brad said something important there. Basically, they're trying to get him to set a hearing date. Because guess what? If Brad agreed to a hearing date, he just consented that the court had jurisdiction. Because why would somebody agree to a hearing date if the court's got no jurisdiction? Why would you agree to be somewhere when that supposed authority that's telling you got to be there can't prove that they have personal or subject matter jurisdiction in this matter? You wouldn't. So Brad's right. That's good that he hit him for 3 times. They're trying to get him to set a hearing. That's good that he's doing that. Because guess what? He's actually costing them money each time too. That's even funnier. Is you make them work real hard for this little bit of money they're trying to scrape from you. But let's move on.
Should I go on or?
I have a question. I guess something to say here with when I was speaking to Christopher James last time, because I was asking you after I watched George Richard, where you stated you're the beneficiary and the court is the trustee, and I asked him about that, and he said, well, he doesn't. I said, would you recommend? He goes, well, no, you're just a woman, you're just a man. You don't have to be a beneficiary. You don't have to state any of that. And so
Chris is absolutely right, and that's you just go in there and say basically, no, I'm a man, but that's what your affidavit of status does. Brad got this affidavit of status. It should be in the court docket when he filed this in this hearing. Listen, it's amazing how these people lose documents. They just sort of, you'll find out, I think, when Brad brings this up, like I said, his affidavit of status, they stated that they hadn't seen it. The court hadn't seen it and the attorney hadn't seen it. And then later in the hearing, she actually references something directly off the affidavit of status. Well, she's either got a great memory, phenomenal memory, or, no, she can't have a phenomenal memory because she said she don't have it. But yet she does reference something directly off the affidavit of status. So it's not like she saw it before and she just didn't have it with her. She's claiming she never saw it. But yet she references a specific thing off of the affidavit of status. Well, gee, that would be called perjury. Because you just told us that you didn't have it, and now you're quoting off of it. And, well, I can't, sorry, I'm going to call Mr. Judge up there, Mrs. Judge up there, hey, this woman just perjured herself. She told you she didn't have this affidavit. Now she's got it. She just perjured herself. Are you going to hold her accountable? What kind of court is this? Is this a kangaroo court I'm in? You're going to let her do that? That's a reflection on you as a judge, So I'll get my little digs in. But let's move forward. But Chris is right. Listen, I'm a man. That's it. I don't need to be beneficiary. I don't need to be anything.
So he said, what Christopher James had said was that what you say when you go into the court is that I'm here to accept any and all verified claims is there a verified claim before this court today? And that's basically his that's what his take on it was. I'm here to accept any and all claims. Is there a verified claim?
And what's Chris saying? Chris is saying, he's saying the same stuff I'm saying, basically. What it means is a verified claim is somebody signed something under penalty of perjury stating that you've violated a right of theirs or you've caused some kind of harm or damage to them. So when Chris is saying, is there a verified claim before this court? That means a man or woman making that claim that they had a right violated or harmed or damaged has to sign the document. There has to be a signature on the document. So if there's no verified claim, what are we doing here? Why are we here? So that's a good point.
Right.
Absolutely.
The judge is
Absolutely.
already on, oh, it's not your turn to talk. Well, who said that?
Yeah. What is this, kindergarten? Are we all not men and women here?
Yeah.
Don't Brad, don't do these phone calls anymore, man. That's nonsense. Oh, let me call you back and do this. And I was, what? No, you deserve, as a man, as a king, and who you are, dude, you deserve to be in an open public court. That is your God-given right to bring forth any man or woman bringing any type of claim against you, man.
And that's exactly it. And that's what I've been hollering about, these people doing these Zoom hearings. And I know some people had to do Zoom hearings for specific reasons. I understood that. But stay out of these Zoom hearings and stay out of these, stay away out of these phone conversation things. You want to talk about, he don't even know, Brad don't even know who he's talking to. he has no idea who he's talking to. That's not Brad's fault. He has no idea who he's talking to in this phone conversation. They could be two, like Richard said, they could be two homeless people having fun with them on the phones. One says they're the judge, one says they're the prosecutor. It's ridiculous. You can't look at anybody. You don't know who's who. And he can't even get a name of the attorney. This is ridiculous. Stay out of these. These are called kangaroo courts. Go look up the definition. That's exactly what this is. This is a kangaroo court that he's in right now.
So don't do these phone calls. They'll mute you. They'll mess with you. They'll do all types of crap. Okay, they did it to me. They've done it to other people. It sounds like that you said that they did it to you, I think. So don't do that, man. And
bingo, they will mute you. I know they'll mute you. I know firsthand knowledge of people being muted that I work with. Ryan, the ex-Marine that you seen the Beth Martin's interview with, he helped his brother out in a small little matter, and he quick got his brother an affidavit of status together, and they went and got it notarized. And like 10 minutes before the hearing, they faxed it in. And Ryan knows not to do Zoom hearings, but his brother decided to wait to the last minute to fight the matter. So Ryan didn't have any options. He had to do it. So they faxed the affidavit of status in, and the hearing starts and hearing's proceeding, and right away his brother is going to try and get his affidavit of status on the record. Remember, when you file an affidavit into a case, into the docket, that's the number of the case number. That's the docket. So when you file an affidavit into the docket, it's technically still hearsay until you put it on the record. You got to put it on the record, and you could either read it from start to finish on the record, or you could do the Robert Fox trick, which they'll allude to a little later here, where you say a couple sentences and it brings your whole affidavit on the court record. So his brother's reading the affidavit of status. He gets a quarter way through the affidavit of status. They mute his brother. Gee, why did they mute his brother? Because they figured out, they know, oh my God, this guy's reading an affidavit into the court record. The attorney's not going to be able to answer this. Just mute him. And that's what they did, and then they try to play their games. Listen, these are kangaroo courts. If they did that to me in court, I wouldn't shut up. They'd have to throw me in jail. The judge can threaten me with contempt all he wants. I'm not going to let some petty Fagershyster attorney talk against me. Not going to happen, okay? And if they're not going to mute me unless they want to, send a bunch of thugs at me and hold my mouth shut, because I'm going to talk in this matter. That's all there is to it. But in a Zoom meeting and this stuff, and a phone call, they just hit a button and mute you. And then what happens is the prosecutor and the judge are having this nice little conversation for 2 or 3 minutes while you're on mute, and all that stuff that just went by for that 2 or 3 minutes, you missed. Now, you can't object to that, because you can, if you got to be sitting there taking notes, write down, oh, this I got to object to, that I got to object to, but that's not how you operate in these things. You're not thinking along those lines. So so what they do is they have this little 2 or 3 minute conversation about you, and there's a ton of things in there you could have objected to, and that's done on purpose. This is why I think they actually like these kind of hearings, because they can mute people anytime they want. And they have more control over these hearings. That's why you always want to be in an open public court. You want witnesses there, okay? So that when I take Mr. Attorney apart, okay, and send Mr. Attorney running for the door because I start asking for his bond information, and I start telling Mr. Attorney I'm going to file criminal complaints against him also, and the people in the court see how I'm handling Mr. Attorney, ooh, all of a sudden, some of the other monkeys might start learning a few things. Did you see what that guy did? You see what he said? And all of a sudden you start waking the monkeys up, okay? They don't like that. They like these kind of little hearings where you're in this, I call this a star chamber. Basically, this is a closed hearing that's a star chamber. So you're in a closed hearing that they can mute you at will. Let's move on there.
And Tammy's exactly right. That's a great way to go about it too. The only reason why I use their trust language is because that's the language that they speak. I don't recommend people doing that, especially because we're on a common law call. The common law ways are really good.
Always you can always say, objection, Your Honor. We didn't do rock, papers, and scissors to decide who goes first.
How do you confirm on a telephone who you're talking to, or that it's even a real court?
You can.
I could have a bunch of buddies in around the kitchen table with cards and cigars, pretending with a speakerphone on.
My cop friends told me that when someone called at night on night shift and said, "Oh, I want to talk to the chief," they just looked over what desk next to them, and the phone, "Chief here," like it could be anybody.
Yeah. Anybody that you were talking to could have been a homeless man. You don't know. They could have just been messing with you.
A point was made earlier, the terms trustee and beneficiary, and aren't those titles, and aren't we supposed to get away from titles? Or do they count there?
Nah, he's right. He's exactly right. Stay away from that stuff. I mean, the closest I'll come to doing that in the court is to say, well, listen, you could just refer to me as the holder in due course. And what I just told him basically is that account you're looking at, that all caps name account, that's mine. I own that. I'm the beneficiary in this matter. Because if you're the holder in due course, you're superior claim. You're the superior claim. And now somebody would have to step forward and state that their superior claim to that fake trust they set up, that illegal trust.
Exactly. Good call. Exactly. Yep. If you know who you are and what position you're in, remember, you can play any game on that ladder you want to. The only one you can't play at the top is God. Now, you can play in the position of the man. You can play a position of a corporation, right? A government position, a judge, an attorney, a defendant, a taxpayer, a resident, any of those positions. If you want to claim the titles, you can. So that was a very good question. And basically the answer there is no, you don't have to claim beneficiary or trustee or any of those positions. Just claim that you're a man.
Bang, James is dead on. Nah, stay away from that stuff. Listen, why would you want to lower your status? You know, I'm a man. You know, I am a man. I'm a man. I'm not going to. That's why, listen, this is why they call you a defendant. Judges have jurisdiction over plaintiffs and defendants and attorneys. And this is why they call you pro se. Think about pro se as having a license to be a temporary lawyer. They're going to grant you a license to be a temporary lawyer. And what they just did is they just brought you down from man, and they brought you down to the lawyer's level. They brought you down to the scum of the earth. That's where they brought you. Brought you down to the level of the scum of the earth is what they did by calling you pro se. So you never accept that title. I'm not pro se because pro se's represent themselves. I don't represent myself. I am myself. You can only represent something that's not you. It's not the thing. The attorney represents, a corporate fiction, or it represents a client. It's representing something else. How do I represent? How do I represent something that isn't me? You know, I'm me. What are you talking about? How am I representing myself? No, you stay away from that. Just tell them I'm a man. So that's what they're doing with the pro se title, and they're trying to lower your status. You know, you got God, man, government, and corporations. So they're trying to bring you down under the judge by calling you defendant or calling you pro se. That's the whole purpose of that. It's just a lowering of your status.
Yield.
Right. It's just like I've used the analogy, like if you know how to build a wood shed or a tool shed, and you go into an architecture firm that specializes in high-rise buildings, you can say you can build just as good as them, but can you?
Proof's in the pudding.
Right.
Yeah. Should I keep it going?
Yeah.
Want more? Here. Okay.
Yeah.
He's requiring further items that the Crown does not actually have. And in addition, he would not accept the body camera by disclosure. He wanted a paper copy, so that was an issue. He also... Sorry, what's that one? Say that again? So we provided disclosure to Mr. Kerrigan, the disclosure that we have, but there's body...
First of all, who's we? And you want to nail that down. Who provided this? Whatever information they provided to Brad, who provided it? You want to get names. You know, don't let these people hide behind this Crown crap, you know, or the sewer authority crap. That literally, right? But no, you don't let them hide behind this this nonsense. You know, no, who's we? I don't know who we is. Who exactly provided me these materials? I need the names of these people, because guess what? These people are involved in crimes against you. All right? And if these are attorneys that are providing this junk, this fraud, I'm going to bar grieve them. Okay? I'm going to send their insurance up, and then I'm going to file a notice of claim against them, supported with affidavits. Now they're going to have to make another phone call to the insurance company telling them they had a claim filed against them. Another problem for them. Then I start filing state and federal criminal complaints against them. Well, that's going to also ring the insurance bell. By the time I get done with Mr. Attorney, he might not be an attorney anymore, because he might not be able to get indemnity insurance. But I need to have names in order to do this. I can't file against the Crown. There's no such thing as a Crown. I need to have the name of the man or woman that sent this information to me. So don't let them talk like we, us, our. No, I need names.
Camera that we downloaded that we wanted to provide to him, but he would not accept that disclosure.
She's talking about video footage. I have no idea what's on the video footage, but it's beside the point. It's nonsense, the video footage, because she has yet to establish she has any cause of action to be in this court, or to move this court, to even to file this. There's no verified claim before this court, which means there's no cause of action stated. Cause of action, basically, it's stating, why are we here? What's the matter? Why are we here? The cause of action. So you got to state a cause of action, and part of a cause of action is there's got to be a damaged or harmed party, because courts are for justicable controversies between real parties, between two parties. Well, somebody did something to somebody else, and they damaged them. The other party's going to come in, and they want to get redress, which means payment for the damages that were caused to them. And that's the basics of law, okay? That's the real basics of law. So if there's no verified claim over here, there's no case.
The body camera disclosure. Okay. So it was put over to today's date with the direction from the judge that perhaps he get counsel, as it sounded like he wanted to make a disclosure application.
Well, guess what? Even the judge that recommended to Brad to get counsel, that's practicing law without a license. I mean, that's not my attorney. The judge is not my attorney. The judge should not be giving Brad legal advice. Okay, and that's what that is. If he's telling Brad to get counsel, here, let me get this straight. Go hire one of my buddies from the bar association, so we can railroad you. That's exactly what the judge is telling him. Go hire one of my buddies. You know, so we can do this railroad job upon you. That judge shouldn't be giving you any advice. That judge is supposed to be a referee, okay? That judge decides what the if the law's valid, whatever the law is, if the law's valid, and then there has to be facts to support what's going on with the law. You've got to have evidence on the record. That judge should not be given legal advice to Brad that recommending he gets counsel.
That's the best that we could determine on the last application, and it was put over to the state for that purpose.
Did you ask for that,
Objection.
Brad?
Never let these attorneys speak.
Right.
Also,
Excuse me, am I able to interject on this?
on information.
Excuse me, Your Honor, am I able to object to some of this, these quotes by the...
Mr. Chad, I just want to hear from one person at a time.
Okay, that's fine, thank you.
Mr. Chad, I want to hear from the Crown first.
Okay.
Thank you.
Oh, objection, sir. Objection, miss. You said you want to hear from the Crown. Who's the Crown? I need a name. Because, listen, miss, I'm pretty sure there's no gold crown sitting on a table talking somewhere. This is a woman claiming to be acting for the Crown. I'm going to need her name. Well, I don't need her name or I'm not going to proceed. That's it. If you're not going to give me her name, I'm in a kangaroo court here. I can't get no justice here. I'm going to end this matter right here. If I can't get people's names that are making allegations against me, and you're letting them speak off record, I'm in a kangaroo court.
Too nice.
So
Objection.
information ending 452, that's the 4-count information.
Right.
I want to make an amendment to count 2. The date is wrong. On count 2, it says December.
So they got their paperwork wrong. So now they want to amend their paperwork after it's wrong. No. Guess what? Your paperwork's wrong. You just lost your case. You're done. All right? You're screwed, lady. You don't get to change dates because somebody screwed up. Whoever screwed up, they screwed up. Your case is shot. You don't get to amend your paperwork.
December 20th, and the correct date should be December 26th.
Is that the judge or the attorney speaking, Brad?
That's the
That's
attorney.
attorney.
The attorney.
Oh,
No, I
objection,
object.
objection, hearsay.
Yeah. 100%.
Just
Not
object.
enough of those.
Yeah, I'm going to reiterate that again. They're 100% right. Listen, don't let attorneys talk against you. Objection. This woman has no personal knowledge of any matter. She can't testify. If she wants to open her mouth and say anything, she's going to have to do it under oath. I'm going to need you to put her under oath, madam. Put her under oath. She opens her mouth, she better be under oath. Or I'm in a kangaroo court. I can't get a fair hearing here. Because I got a woman claiming she's speaking for a corporate fiction who wants to do damage to me, and I can't even get her name, and she's got no personal knowledge of anything coming out of her mouth. This is a hearing? This is a fair hearing? This is an embarrassment to you as a judge.
And I will follow up with you. One moment, please, Mr. Kerrigan. Don't worry, I won't forget about it.
Thank you.
Ms. Sorry, I spoke from the Crown again. I just want to hear where we're at in terms of, so your understanding is there's disclosure issues. One, he won't accept, he doesn't want the body-worn camera footage, and you think there might be an application. Are there other matters other than the body-worn camera issue that's disclosure, or some things he wants that you're not prepared to provide?
Correct.
So it's at least 2 parts to the disclosure issues.
Correct.
And then one of them is, and then the next thing is an amendment.
Let me reiterate this again. You got a judge talking to a prosecutor. Neither of them have established jurisdiction in this matter. Neither of them have established they have authority, that they have any legal standing, or have any personal knowledge of anything in this matter. So this is a hearsay conversation going on. You got the prosecutor that has no idea what happened that day, and the judge that has no idea what happened that day, yet they're having a conversation about Brad, what they're going to do to Brad. This is a kangaroo court.
That you're seeking on, Crown is seeking on count 2 of the information in info.
Objection. The Crown speaking on count 2. Who is the Crown, miss? I need a name. Listen, and you do this, if you have to do it 500 times in these kangaroo court hearings, you do it. Objection. You're saying the court, the Crown this, the Crown that. Who is the Crown? I need a name.
5-2.
Correct.
All right. And Mr. Kerrigan,
My name is Brad, Your Honor.
Good. That's good he did that. Don't let him call you mister. That there's, as you know, they use that as a like a form of authority, jurisdiction over you. Basically, it's sort of lower your status. No, so Brad did good there.
I beg your pardon?
You can call me Brad. My name is Brad. Thank you.
It's not the custom in this court nor my...
It's not the custom in this court. Well, ma'am, I don't really care about the custom of this court. I have rights. My name is Brad. I don't care about your customs, because these customs they're talking about, this is called the rules of civil procedure. So let me get this straight. These are supposed to be open public courts, okay? These are the people's courts. But what the Legal Society did, the Bar Association, is they went out and the Legal Society, which is a private organization, creates these things called rules of civil procedure. And what they did in these rules of civil procedure, what they allowed these attorneys to do things they couldn't do otherwise, things that are in violation of the United States of America Constitution and the Canadian Constitution. So it lets these attorneys do things they otherwise couldn't do, like coming into court and speaking for Mickey Mouse or Donald Duck or the Crown. Because in a real court proceeding, that can't happen. In real real law, that can't happen. But under the rules of civil procedure, they can move that way. So that's one of the things Chris and I have been talking about, working on. We're gonna try and knock the rules of civil procedure out. And so don't let them tell you about their customs and this and that. I don't care about your custom. I'm not of your tribe. Sorry, I'm not one of your people. You know, it's my custom. You can tell me it's my custom. You call me by my first name. That's my custom. I don't care about your custom.
Personal practice to call people Crown or accused persons by their given name, and so I
You
won't
just said let the Crown speak.
Thank you for the honor.
Yeah, she just said that.
She said that they're called by their given name. Is that woman's name? Is the prosecutor named Crown? Is that her name? I don't think so.
First name,
It wasn't an offer. It was actually a statement, Your Honor. But anyway, it's okay. I will.
Bradley?
Yes, Bradley would be fine. Yes.
All right.
And who am I speaking with, please? What is your name? For the record, who?
Judge Schreier.
Judge Schreier?
The record shows, yes.
Judge Schreier.
What's your first name? I need your first name too. Judge Schreier. Who's that? You Mary Schreier? You Bob Schreier? Who are you? Get her first name too.
Okay. Now, I would like to
No
make
first
sure
name?
that we're on par here. And what I believe there was I would like to just read my statement onto the court record here. So I understand that accurately state that I am to accurately state the facts, and if I am inaccurately stating facts, that I may be subject to perjury under the laws of Canada. And after qualifying my testimony on record in the notarized affidavit of status that was presented to the court, I hereby state that everything in this affidavit of status is truth, the whole truth, and nothing but the truth, so help me God.
Now, Brad stumbled over it a little bit, but he got it on there. He got it on the record. That's the Robert Fox trick that you just heard. And sort of, you state that it's my understanding that I am to, state the facts in this matter, and that if I inaccurately state the facts in this matter, that I'd be subject to penalties of perjury. And having qualified my testimony, can you tell me your testimony? Having qualified my testimony, I now incorporate my affidavit of status as if it was stated in full herein, and I further state that everything in my affidavit of status is the truth, the whole truth, and nothing but the truth. Bam! Now you just took that out-of-court testimony, the hearsay testimony, the affidavit, and you just put it on the court record. Guess what you just did? You just got facts on the record, because your affidavit are facts. So now the other party's got to rebut your facts. Well, who's going to rebut the facts? Is the Crown, is Mr. and Mrs. Crown going to come in to testify and knock Brad's affidavit out? I don't think so. Is the prosecutor can't? She's got no personal knowledge of anything. She can't knock Brad's affidavit out. So Brad has facts on the court record now that they can't dispute. Now they're going to try and, if you know how to handle this, Brad's got checkmate on him right now. And you handle this properly, they can't move. They'll try to move past that and try to ignore Brad's affidavit. You stand on your affidavit. Once you get that affidavit on the record, like he just did, I'm done. I'm standing right here. Hey, judgy miss, judgy up there. You know what? I just got my affidavit on the record. I have the only facts on this court record right now. We can't proceed until I get a response to my affidavits. Somebody's got to come up and challenge my affidavits here, or I'm the only one with facts on the record here, because the Crown's a corporate fiction and can't put facts on a record, and the attorney has no personal knowledge, is not a qualified witness, therefore she can't put facts on the record. So that means in this court record, I'm the only party with facts on the court record. If no one can challenge me, I win. It's over. We're done. So Brad did right, but yeah, I mean, that's a powerful thing, and get used to doing that. It's good he did that, because that will now cause problems for the prosecutor, because Brad now can stand on that affidavit that's in the court record.
And I would like to enter that statement of status or affidavit of status into the record. So that was sent to the Crown, and it was also sent to the registrar. So you should have a copy there. Do you have a copy in front of you?
No, sir, I don't.
You don't?
They never have it. Nope, I didn't get it. The prosecutor don't have, nobody's got his document. Gee, I wonder why they don't have Brad's affidavit of status. Because Brad's affidavit of status took all their presumptions in a way that they're moving this trial under. I'm not going to call it a trial. That's an insult to trials. That they're moving this kangaroo court against Brad. So, of course they don't have that document, because that document destroys their case.
Don't have a copy of the affidavit that was sent to the registrar and to the Crown?
No, sir, I don't.
Well, then we need to adjourn this matter until you have it before you.
Excellent. Yeah. Hey, listen, you guys don't even have the right documents in front of you. I sent you guys documents, affidavits. You don't even have the right documents before you, and you're moving a matter against me without all the information? Is a kangaroo court.
And I would ask that we adjourn this until you get the proper documents in front of you, please. And I would set for maybe next week, next Wednesday.
In the meantime, I'd like to talk about the two.
No, I can't speak to anything on this.
Bam! Nope. See. In the meantime, she wanted to move past his affidavits, because, and if he let her move past those affidavits, he nullifies his own affidavits. No, he's got court testimony now, facts on that record. She wants to just move by that, and he's right. No, I can't move past anything. I can't do anything right now until these are addressed, these affidavits are addressed. You people don't even have the affidavits in front of you, yet you want to keep proceeding in this matter. Well, gee, what if the affidavits destroy your case, which they do, and you want to proceed in a matter where you don't have jurisdiction, you're just moving ahead. And these are the dirtballs that these judges and attorneys are, and these judges and attorneys are on the same team. They're bar members.
Matter unless the documents that have been submitted are in front of you.
Good job, Brad. Don't let them go forward.
And with respect to the amendment of the date.
I can't speak to any of this because I have not received any. I object, Your Honor. I can't speak to any of this until I see the tickets that she talks about. I object to any changes to any of the application because there is no proof. She has to put evidence. There's no evidence. And I just, this has to be adjourned until you get on court record the proper documents so we can discuss those documents as part of the application, please.
He's dead on right. So I think this matter, this is about a march that Brad was at, and he got tickets, citations. They didn't even give him the citation. He don't even have the citations. He don't have the tickets, and they're moving this matter against him. This prosecutor's got zero evidence on this court record. She's got nothing on the court record, and this judge is letting this court move. You know what, Brad? Go file bar grievances against the attorney and file judicial complaints against that judge. Go ring their insurance bell and then go file claims against them, notice of claims for a substantial financial settlement, and support it with affidavits. These are criminals you're dealing with right here.
Very
so
reasonable.
If we can adjourn this till next Wednesday or Thursday, that would be fine. And then you'll have time to have them in the court record, and you can actually view them when I speak to them.
Very reasonable request. But I wouldn't even agree to even come back for any kind of hearing, because I don't see any verified claim in this court, and I don't see any party here that has personal knowledge or standing in this court. Nobody's got standing in the court. The prosecutor wasn't damaged or harmed, and Brad didn't violate any of her rights. So what is she doing in here talking about Brad? Let's bring the party in who was damaged. There is no damaged party.
Okay, well, subject to what you have to say, Crown, sorry, I can't see your name, but subject to what you have to say.
Can the Crown put her name on record so we know who's speaking on behalf of the? And to make statements, she must be under oath, because we know that, to submit testimony of fact. So I would like to know who the Crown is who's speaking on that side, please.
Bam! Deadly. That's deadly, basically. He nailed her. That's it. She's over here talking. She's got no personal knowledge of it. He thinks she's not even under oath. And this judge is what's happening is this judge is letting hearsay testimony in her court. That's a crime, okay? What this judge did, that she's committed a crime in this court by letting somebody with no standing in the matter, no personal knowledge, make allegations against Brad. That's a crime this judge is involved in.
I demand
for the record.
Demand, require.
Mr. Carrington, I'm going to ask you to just hold your tongue for one moment, please, sir.
Certainly.
And I'm going to ask the Crown.
You're under her skin.
I know.
Mr. Carrigan's argument or submissions regarding
Good for you.
The date. As far as
Objection. My name's Brad, not Mr. Kerrigan.
Justify not amending the date at this early stage, and so
Well, there's no evidence.
I propose to amend the date.
Well, Your Honor, there's no evidence.
26th.
An objection, you
Yeah,
can't
but
amend
there's
the
no
date, Your
evidence
Honor.
to show that what the date is. I've not even seen a ticket, Your Honor. So she hasn't produced a ticket. So what
Go.
evidence? She's changing dates. She
Yeah,
hasn't
Brett,
produced
are you
evidence. Why are
falsifying
we even here
documents?
talking?
Richard hit it. This attorney is falsifying documents. In other words, think about this now. The supposed cop that wrote this, he wrote that date on there or whatever the date was. He messed it up, it sounds like. So the attorney wants to amend something that she wasn't a witness to. She's got no personal knowledge of anything happened on this so-called ticket document, and she wants to amend it. That's called fraud. Okay, that's now she's creating a forged document. That's fraud. This judge is letting this attorney commit a crime here. This is a crime family you're watching. This is when you start to understand this, and you look at what's going on. This is how ridiculous these people are with what they're doing, and it's good because these guys see it, and Brad's seeing it now, and more people are starting to wake up because we're just bringing it down to the basic elemental levels. We just fell off the turnip truck. We're stupid. We don't understand any of this stuff. All we know is this woman's in here claiming to speak for a fiction. I don't know who she's speaking for. Where's the fiction? Is that Mr. and Mrs. Crown coming in? And when you start, I call it Barney Rubble stuff. It's Barney Rubble statements and documents. Fred take ball, Barney want ball back. We're just asking basic questions. She don't have standing in this matter. What's her name? We're basic stuff.
They have a responsibility. They just can't
document.
accuse someone. There has to be evidence. Show the evidence. And I've asked for the evidence. I put it in writing. That's why this affidavit, before you make any judgments or determinations,
Absolutely.
the affidavit that was sent that you haven't received from your registrar
And we're all
needs to be
witnesses.
seen. And we need to go over the evidence.
Right, we are.
So please, we can't make judgments until such evidence is before the court.
Good
Now I'm
job,
asking
Let's all go after
that
her.
we do that. I'm
Dude,
representing
kicking ass, man.
that is done. Please. Thank you.
So you got this guy with no law education that's now schooling a judge. He just schooled her. Listen, how are you people going to make decisions when you don't even have facts before you that you need to make a decision? Listen, this judge is either a dummy or she's a criminal.
Thank you.
Your Honor, if I might. Please, sorry. So
This is Gaskin.
Mr. Kerrigan keeps talking about tickets, and so I think it was tried. Efforts were made on the last occasion to explain that these are actually long-form information, so they're not a ticket per se. They're long-form information, so there is
No, they're not. They're tickets. They were written out by the officers attending. They were written out by the officers attending. Don't make up stories, please.
And this is the problem with hearsay. She don't know what happened that day. She wasn't there. Yet she's going to stick her face in this matter and tell the judge what happened. She has no idea what happened. And that judge is a scumbag for letting her talk.
You don't have first-hand knowledge. You shouldn't be testifying. And if you're going to put it under oath, please. This has to be under oath. If she's going to speak to this court, and if she's not under oath, this testimony cannot be heard.
Oh, Brad.
It's exactly what
Whoever
she's
she
doing.
is.
She's doing facts. She's representing facts that are not
They just had to
facts.
piss him off just
She
a little
just did
bit.
it. I object to that. So unless she's going to come under oath and give a testimony of fact, then she has no right to say anything. And that has to be represented in this court.
Bam! Deadly! It's deadly stuff, man. See, they don't think the monkeys know about this stuff, but the monkeys are getting smarter. You know, they're learning from a couple people that, we can expose this fraud. The monkeys are getting smarter, and the monkeys are are asking relevant questions, and they're making relevant statements. Hey, you got to basically strike everything she said today. She's got no personal knowledge. You got to get her under oath. Listen, like I said, this judge is either a dummy, which I doubt. I just think she's a criminal.
She can't just spew out. She can't just come out and make up statements. She has to be under oath. She's not under oath.
And who is she?
So unless she's under oath, I don't want to hear what she has to say.
Right. Unless she's under oath, I could care less what she has to say. Bang.
Do you accept hearsay?
No. It doesn't work that way, please. I have.
No, it doesn't work that way. Schooling the judge again. He's right. It doesn't work that way. Only in this little kangaroo fake court I'm in, it works this way because you people got the judgment already done. This is just a little circus you're running right here. You know, you just want to make it look like there was some kind of due process going on. You were going to railroad me, basically. That's all this is.
The right to speak. I am man. I'm in this courtroom. I'm sorry. I'm not trying to interrupt you, Your Honor. We have to make sure that the protocols are followed. And she's not following protocols. She's making up
all have to stop
statements.
doing that.
She's making up facts. She cannot do that.
Mr. Kerrigan?
Yes, sir.
Gotcha, Mr. Kerrigan.
I'm wondering,
She amended the date, so the judge just amended the date in a matter she's got no personal knowledge of. The judge just committed forgery and fraud, right there on tape. She amended a document she's got no personal knowledge of. Wow, right on tape. That's forgery and fraud. That judge has no idea. The prosecutor doesn't have personal knowledge of what's on that document, that date. And neither's the judge, and yet the judge amended it. They're just making this up as they go along.
there are no tickets. You have disclosure. You're missing some parts of disclosure. If you want to bring a disclosure application, you can an application for more disclosure. You can do that. It will not be held today. I will not tell you how to do it. You have to perhaps hire a lawyer or get some advice.
Trying to get their lawyer buddies there hired again. Go hire one of our friends so then we don't have to deal with your affidavit there, Brad.
And I don't have to be represented. I represent myself, as I stated.
Ooh, that's the only one made me cringe. That don't represent yourself. You don't represent yourself. You are yourself. I am myself. That's a small minor thing.
Earlier in this, I am before
Can't represent
the court,
yourself.
and I reserve all
I am
my
myself.
rights. I waive no rights
That's right.
ever. I am the
It's impossible to
beneficiary of the
represent
court today, and no one in this court has provided evidence that I am not the beneficiary.
Or evidence of
Therefore, I am
jurisdiction.
the beneficiary of the court.
No
And I
personal.
hereby
Yeah, instead of hitting the beneficiary part, you stick on jurisdiction. Courts can't hear matters without having jurisdiction. They need personal jurisdiction and they need subject matter jurisdiction. A real quick review of that. Personal jurisdiction, a court attempts to gain personal jurisdiction when they send a process server to your house. Well, it's actually the other party sends the process server, but the court issues the summons. They stamp it. But when that process server serves you the complaint and the summons attached, that's the court's attempt to get personal jurisdiction of you, to get you into the court. Okay? But they need both personal and subject matter jurisdiction. Now, even if you went into that court, there has to be a party with standing that's coming at you. Standing means that you had a right violated or you had harm or damage caused to you, and that the other party that you had served with the summons, they're the direct causation of that harm and damage. So that's what process of service is. So that's personal jurisdiction. Like I said, subject matter jurisdiction is you need standing. So what he should have done here was go after jurisdiction. Basically, hey, listen, I never received service of process. You don't do service of process through the mail. If you could do service of process through the mail to start legal proceedings, gee, couldn't I just take a cheap stamp and smack it on an envelope and send it out to the other party? Why would I hire a process server for $100? Let's put a stamp on an envelope and send it to some party I want to sue. Can't do that. Doesn't work like that. But I guarantee that's what they did to Brad in this matter. I'm sure they did. There was no process server showed up to Brad's house. They gave him a mailing, a regular mailing, and legal proceedings are not handled that way. They're not initiated that way through mailings. Okay.
I appoint this court as trustee to settle the matter. Now, I have jurisdiction in this court at this moment. You are an officer of the court. The Crown has no jurisdiction whatsoever, and they have no right to speak unless I allow them to speak in this court. Now, what I'm saying is they have to have evidence, Your Honor. I'm trying to be respectful, but they have to have evidence. There's no evidence, and all I want is the tickets. They say there's tickets that were issued.
No evidence upon the record.
You're even changing the date now to accommodate her when they're taking. How can they just change the date? They have to have the evidence to prove the date even
Tampering
existed.
with evidence.
And the date that you're talking about now, the 26th, first it's the 20th. So they arrest me, throw me in jail overnight based on they don't even know what date's on the ticket. Are you kidding me?
Golden ticket.
Let's be realistic.
Brad.
I get my rights under God as endorsed by the Charter of Rights and Freedoms. And above that, yes, hello? So what I would like the court to do, Your Honor, I'd like you to adjourn this until you get the affidavit that was served and the different documents that were served to your registrar and to the Crown. They should be before you before we move forward on this. And I would ask you that you please adjourn it for a week so that can be done. Before any more representations are made. I would appreciate that.
Halt on court proceedings.
I'd like to hear from the Crown, as a practical matter, how might this matter proceed? Because a lot of the...
Oh my God, the judge is talking to the prosecutor. Both parties, as we said, have no personal knowledge, no standing in the matter, and the judge is asking the party with no standing, no personal knowledge of anything in the matter, no evidence of jurisdiction, how she would like to proceed. You haven't even established jurisdiction yet. What are you doing asking her how she wants to proceed? This is really, you know what's sad about this? This is not the exception. This is the rule. This is what's going on in these courts. This is the rule of our legal society-run courts. They're criminals. They're a corrupt organization, the bar. They're criminals.
She has no standing in this procedure.
Absolutely.
She has no standing to tell you how it should proceed. And you know that.
I'm asking for her input. I heard your input now.
Wait a minute. He just nailed her. She's got no standing to be talking. But the judge turns around and says, well, I'm asking for her input. Well, she's got no standing. She's got no input. She can't have input unless she has standing in the matter. And the judge still says, well, I'm asking for her input. Gee, why don't we go ask the guy living under a bridge outside what his input is in this matter? Because he's got as much standing as she's got.
She has no standing in this matter. She's not a witness. She has no first-hand knowledge. Why does she have input? What right does she have? She has no right. She has no standing.
You're a severe misunderstanding of the process, sir. I can't help you.
Yeah.
He's got zero misunderstanding of the process? Oh, I don't think so. She's got zero misunderstanding of the process. Let me explain. Let me translate that for her. Listen, Brad, you don't understand. We're gonna railroad you. You're supposed to play along like the other monkeys. You got to come along like the other monkeys. You don't understand the process. We bring you in, we give you this little show trial, then we railroad you, and you just go along with it. That's our process. That's what she just told him.
Yeah,
Well,
there's that.
it's not a misunderstanding. I understand my right. Oh, well.
I can advise, Your Honor, with regards to the affidavit of status, that will, in my submission, offer no assistance to the court. It does not ask for.
That's your opinion. That's your opinion.
Right.
I'm still talking. It just speaks about
I object.
the man.
What's her status?
Property.
I object.
So it doesn't actually assist in establishing.
I object.
You
What's
just
your
said that you
status,
didn't see
ma'am?
the affidavit of status. Now you're quoting from it. You just said you didn't see it. Now you're quoting from it.
You bonded?
I'm gonna lie.
Are you listening? So I can hear from. I can.
Now, she said she didn't see it, that she's quoted from it. I'm telling you. Listen, the people think this law stuff's dry and boring. This stuff starts to become fun. When you start to get to this level and you start to know what to hit, it's like taking dummies and like grabbing them by the nose and moving them around, It actually starts to become fun because you're seeing an experienced judge and an experienced attorney being tripped up by some guy with no law education. I don't know how long he's been doing this, probably a short time he's only been involved in this. Yet he's got a judge on the ropes and he's got an attorney on the ropes. Think about where Brad will be in like a year from now if he stays with this stuff. Not only will he have him on the ropes, he'll knock him through the ring. He'll knock him out of the ring, right through the ropes. He'll knock him. Look what he's doing to him already with just the basics that he knows. He's killing them. He's destroying these people in this hearing.
Can we hear one person?
I apologize. I won't interrupt.
No, I'm gonna have to. We'll mute you for now, so until we.
We'll mute you for now. We're just going to mute you so you can't object, so that we can railroad some more stuff through.
I'll make sure I'll hear from the crowd. As a practical matter, you could take some notes.
Mute me? I would have just come out.
Well, I need to be able to be part
Objection.
of the
If you
process.
mean me denial of due process.
I need to be part of the process. So
Yeah, Brad's got to be able to object. She's saying I'm going to mute you. No. Lady, listen. I can only appeal what I object to. If I don't object to something, you can't appeal to it. If I don't object to something, it's not an appealable issue in an appellate court. I got to object to it, okay? How do I object to something when you got me muted? I mean, this hearing just keeps getting more and more ridiculous.
I would appreciate that, that I am part of the process. And, in these decisions, you're talking to the Crown with disrespecting.
Thank you. Please proceed. As a practical matter, how can we move this forward?
Can you pause for a second?
In a practical matter, how can we move this forward? Because we're screwed. This guy's got affidavits. He's asking like real relevant questions like, geez, there's nobody here with personal knowledge in this matter. Nobody here with standing. How do we move this forward? How do we railroad this guy that understands what exactly we're trying to do to him?
What is the term, similar to color of law, what is the term when they're faking a procedure? It's having a brain fart.
Simulation of legal process.
That's what's going on here.
It's a simulation. Yeah.
Isn't this
absolutely.
entire thing a simulation of process? I mean, we're on the
100%.
telephone with strangers who are making up stories, don't have their data, they're lying through their teeth, and they have no jurisdiction. None.
It's
No standing, no nothing.
Caught in a
It's an
lie.
act on a stage.
Brad, you freaking rocked it, man. That was
Did you
awesome,
ever?
dude.
I'm
Dude,
glad
that
you
was
played
awesome.
that. I'm
No
glad
wonder
you
you were
played
so
it.
proud yesterday.
We're talking about acting
So-
like a man and just doing it because you already have it in you to do it and you just showed it. The only thing I would say is the asking. You're just too polite. Can I ask?
Quit asking. Yeah.
Yeah, Tammy's
No, Your
100%
Honor.
right.
I
No, you
require-
Require. It's
He's a
required.
man.
Yeah, don't
Yeah, Tammy's right, but listen, I think that's just a nervous thing. I mean, listen, Brad's under. I mean, he's under a lot of pressure here. So you might, that's like a slip up calling him Iran or whatever. So he's under a lot of pressure. That's just a listen. This is probably his first time out of the gate having the knowledge he does right now to actually address this kind of matter. And I'm stunned that he remembered and pulled as much out as he has, that he retained so much that he was actually able to use it under fire. Like I said, he's sort of like a rookie. He's probably just, he ain't been doing this a long time, and neither have I. But guess where he'll be in like a year? I mean, he's going to be like, he'll take them judges and the attorneys apart. And because he knows the law. He knows the real law. You need to have witnesses, and the witnesses need to have personal knowledge of a matter. And they need to have standing in the matter. Oh, and they need to have jurisdiction in the matter. This is basic law, and no matter how corrupt these judges are and these attorneys are, when this hits a certain level of court, when you go up to the, like here, it's the federal courts, a lot of that stuff's going to come out because, there is a little bit of integrity left in these the higher courts. The higher you go up the chain, you start getting up to the higher courts. They play it a little more by the book. They listen. The higher ups, they know if there's no witness here and there's no evidence, you can't win. You just can't win. Not even in this twisted little system we set up. Got to have evidence. Got to have witnesses.
Apologize for anything you're saying or doing in there because you're doing it as you, as a man.
Except when you said that I represent myself. Apologize for that.
Yeah. And sorry, what was the phrase again? Richard, what was the phrase again?
What phrase?
Simulation.
Did you see what the attorney said right before we paused it? She said, how can we proceed with this?
That's what you said.
Because they were stuck. So they're like, how can we proceed? What are we
I would
going
have
to
said
do
exactly.
Here?
You have no recourse.
What can we make up now?
Yeah. That phrase is called
how can we proceed? I would have jumped right on that. What the judge said. How can you proceed? You could dismiss this with prejudice right now because there's no evidence over here. There's nobody with standing over here. What are you moving? Are you kidding me? This is a kangaroo court. You better dismiss this. I'm going to file a judicial complaint against you, a bar grievance against you. Then I'm going to file notice of claim against you, affidavit against you, and then I'm going to start filing state and federal criminal complaints. And when I'm done with you there, then I'm going to bring you in a real court, and I'm going to thump you guys for the crimes you committed here, the numerous crimes you committed here.
That phrase is called a simulation of legal process. It's a sham.
Yeah, yes. I knew what it was. It's just I could not draw it out of my memory. Simulation.
Oh, it's all good. Hey Brad, go listen. I posted something in the chat, a link to Robert Fox. If y'all haven't listened to Robert Fox, I highly recommend go listen to it. He will just fire you up, and his story is incredible. He gave a weekend seminar that somebody recorded and then it got put on the internet. It's fantastic. The guy's 10-0 against the federal government. So lots of good stuff. That's where I got that testimony from, was from Alphonse, who got it from Robert Fox. So
how long ago did you post that? I don't see it.
You didn't. Hold on. Hold
I
on.
don't see it either. I'm looking.
It's great.
I posted it. Yeah. I sent. Hold on. Let me just resend it.
So Richard, it's not I'm representing myself. It's I'm presenting myself.
No, I am myself. I am myself.
So don't even say I'm presenting myself.
No, because you're a man.
How are you presenting yourself?
As a man.
As a man.
Okay.
I am myself. I present myself.
Or you can just say I am myself.
Yeah.
Okay.
Yes, it's better.
Okay.
I am myself. How are you presenting yourself as a man? Okay. Yeah, you can do that. I mean, that's fine. But I would just say I am myself.
Present yourself as anything when you are who you are.
Exactly.
Yeah, can you
know
make
who
an
you are,
exact
act as
copy
who
of
you are.
yourself and give it to somebody? Not really.
Papa used to say that, didn't he?
And when that attorney said
am.
that thing about status, you could have fired right back objection. What's your status in this, Your Honor?
Excellent point, James. Yup, he nailed it too. What's her status? Who is this woman coming at me? No jurisdiction, no authority, no legal standing, no personal knowledge of anything. Who is this woman?
What's her status?
Yeah.
Who the hell is she? She don't have a crown on her head. What are you talking about, a crown?
Yep. And Brad, if these people want to go against you in an open court, man, because don't show up to any more of this bullshit. That was nonsense that they Yeah, don't do any
You
more.
can
of that
handle
stuff.
this all through the paperwork, man, way
You
faster.
can. You can.
That was the loudest crack I ever heard in a courtroom when you brought that hammer down.
Oh, dude, you did awesome, man. You got judicial complaints. You got bar grievances to file. Notice of
Golden-
claims to file.
Golden ticket.
Yep.
How does it end?
You just got to use
Him getting paid.
require and demand a lot.
Let's hear
you
the
want to
rest
hear
of
the
it.
rest?
Yes.
Yeah.
Please.
Right now they mute me and then I come back. Watch what happens.
Yeah, but this is better than role play, Brad. This is
Yeah.
great.
Matter in front of a trial court if that's the intention of the Crown. He has a right to a trial. As I said before, Mr. Carrigan, these are extraordinary charges. There's no doubt about that. This is extraordinary legislation.
What the heck is extraordinary legislation? Extraordinary charges. Sounds like Brad blew up a store or something. That's extraordinary. Extraordinary charges for what? Being at a march? What are you people talking about? And I could have swore she just said he had a right to a trial, but then later she criticizes it and states that that this court they don't do trials in this level court. But I could have swore that just came out of her mouth.
Extraordinary. See, they're setting
Not legislature.
Well, I object to your.
With regards to setting
See,
up
I'm
trial
muted
dates
right
then,
now.
Am I able to speak now? Were you speaking to me, Your Honor?
4-6,
Were you speaking to me?
in time. The Crown has
So yes, that's the two.
yes.
That's disgusting.
The Crown has one witness. Now, I just believe that perhaps a half day.
Believe, perhaps.
So the Crown has one witness.
The Crown is a witness. What's the witness witnessing to? What's the Crown of a witness to? That Brad was at a rally? I mean, God, what is it?
By the nature of the submission, that Mr. Kerrigan continues that they will take
I'm
more
muted.
than what would normally be required is my submission.
I would think you might even need more than a half a day. That judge might be tired of it after half a day.
Right. So if the court wishes to set that, I'm happy to do that. And then I would suggest we also set another day, although I do have a few more witnesses on the next information, that being information 0452.
And before, listen, he's going to be able to knock this out with the paperwork alone. But listen, you want to get the witness list. You want to know who these people are that are going to come in. What are they witnessing? What are they going to testify to? Because this court, I wouldn't show up to any more hearings in this thing. I wouldn't even let him set a hearing like he's done already 3 times. This is a kangaroo court. I'm not coming in here. This is ridiculous. I'm going to smack an affidavit across your heads, and unless you guys want to answer that affidavit, go away. Because I'm going to smoke you people if you keep coming at me. I got affidavits here. I can go on there and testify viva voce, which means in my own voice in the court. I could testify viva voce in my own voice that you people are committing crimes here and everything in my affidavit's true. And there's not one of you people that can come against me.
So we might actually want to set up some more. I'm not sure if we can do that today or how the court wishes to proceed, but I can do as the court wishes.
And we're paying for this crap.
And
Yep.
in terms of if Mr. Kerrigan is going to bring an application, for example, for additional disclosure, to do that any time prior to trial.
That's what I would, yes. Does the court have a trial readiness? I know in Edmonton
This
they
is
have
just their little party going on, right?
people who have no counsel are just able to address the court as to whether they're ready to go and proceed to trial. Does Calgary have a courtroom like that?
No, we don't. When people are represented, we usually give them a trial confirmation date in advance to confirm that they're ready to proceed so that the trial time is not wasted.
Then perhaps we can follow that as well on this one.
What a joke.
And,
They're wasting the court's
and,
time.
Mr. Kerrigan, in 1 second, I just want to make sure I understand the process that's being proposed by the Crown. This is not affecting
Do you have the
Mr.
Crown's
Kerrigan,
name in writing
all of
anywhere?
which are, as he would say,
I do, yeah.
Good.
I've got, just listen what happens, because I get her to, I start, just when this ends, it's another minute or two, and then I start going into her face a little bit.
and the setting of that, would that be done? We don't do that here. That would have to be done
How long did they shut you out? Like 5 minutes?
I'm coming back now.
And understands now what's being proposed in terms of getting him the opportunity to have his proper say in a court, in a trial court with proper witnesses under oath. Mr. Kerrigan? Sorry, I'm just unmuting. And was it a day-long trial? Well, I think it's 2 half days is what's been 2 half days. Mr. Kerrigan?
Yes, hi. So you're proposing a trial by jury, is that?
That's what it sounded like to me too. I mean, it sounded like the judge was talking about a trial by jury, and then the judge is going to say no. There's no trial by jury in this court, in this level court. Am I hearing things? Is Brad hearing things? I could have swore the judge was talking about a trial by jury.
Is that what I'm hearing?
No juries in this level of court.
Are we idiots? I could have swore they were just talking about a trial by jury.
I'm sorry?
There are no juries in this level of court.
Right. Well, I would insist on a trial by jury. But on the other side there, I just want to ask, where's the probable cause? And when this lawyer is saying that she has evidence, I have seen no evidence. I've asked for the tickets to be established.
Real quick, probable cause. Probable cause is a crime. Probable cause is not a code infraction. If I go through a stop sign or a red light, that's not a crime. That's a code infraction, okay? Think about it this way. If a cop see me go through a stop sign and he couldn't get to me and I got in my house, he couldn't come in my house. He didn't need a warrant to come in my house. So if he ran to a judge and said, hey, I seen this guy Fagiola go through a red light, and I need a warrant to go in his house, Judge. The judge is going to laugh at him, because no judge is going to issue a warrant to come get me because I ran a traffic light, because it's a code infraction. It's not a crime. Crimes involve men and women that had a right violated, were harmed or damaged. That's a crime. So when Brad's saying there's no probable cause here, he's dead on. Where's the criminal? This is a criminal matter. He said that they're moving against them. Well, where's the injured party? You gotta have an injured. You gotta have it's called a corpus delicti. You gotta. It's the body of the crime. That's what that means. So you gotta have an injured party. You know, we can't have a case, a criminal case, without an injured, damaged party. He can't injure the crown. So he's saying there's no probable cause here. No, there's nobody stated that they've been injured or harmed by Brad.
Where is the personal or subject matter jurisdiction? And where is the probable cause? There's no injured party. So this is a criminal matter. I would like to know, when you're talking about these various settings, who is the injured party? And if there's no cause of action without an injured party, then there's no probable cause. So what are we talking about here? She's refused to bring to the table the actual tickets signed by these witnesses. And without those signatures of the time and date, now she's changing the date of when it occurred.
Yeah.
Now, why? I mean, this is...
You can't change the date on the ticket. If the cop screwed up when he put the wrong date on the ticket, he screwed up. That's it. Game's over. There's no case. That's tampering with evidence. That ticket is supposed to be evidence that cop... Evidence of what? We don't know. He was at a rally? Okay. So... That ticket's supposed to be evidence. You can't tamper with evidence. You can't change. Think what's happening here. They're going on to this citation thing, this ticket thing they're holding them on. So then basically the charging instrument is the ticket. Okay? So now, since they screwed up the charging instrument because it's got the wrong date on it, they want to modify it after the fact. They're tampering with evidence. That ticket's evidence of that event that day. And because they got it wrong, they want to change the date on it. This is fraud. This is forgery. And this is tampering with evidence. These are major crimes. What'd she call that? Exceptional crimes or something with some crazy thing she used? No, these are exceptional crimes right here. These are major crimes.
Obstruction of justice right now. Because what she's doing is she's railroading a case into court for no reason. Now, you as the presiding justice. Or is it a judge or justice? I'm sorry. This is provincial court?
Right.
Are we in provincial court right now? Is this a provincial hearing?
Yes, sir. You're in provincial court. You're in provincial court.
Right. Okay. So it will be elevated to Queen's Bench? Is that what?
Not to my knowledge, sir.
No.
Not
Okay.
to my knowledge.
Well, it will be.
These are summary conviction matters. Those are tried in.
I think you just said these are summary judgment matters. In other words, we just make decisions without any trial, without any juries. We just decide. In other words, the judge is the judge and the jury. Well, they're not courts for men and women. Okay, I know over here we have in the United States of America, we have a right to trial by jury in all matters, and I'm going to guess Canada's probably the same way, that you're entitled to a trial by jury.
Okay.
You know, it said I
So I object. I do object to any trial or any date being set for this unless there's probable cause, which there has been none. She can't even show me a ticket. And I'd like the Crown to establish, or the court
Can't
to
even show
establish
you
a
her.
personal or subject matter jurisdiction. Where is the probable cause? There's no injured party here. So when she says it's a serious matter, who's injured? Where's the proof there's injury? There is none. So where's the ticket from the officer that represents there's an injured party? That's why they're not presenting the ticket. So, and I don't want to get into the arguments.
This is like comical. You got a guy schooling a judge and schooling an attorney on. I mean, listen, you don't have to be a rocket scientist to figure out that this is easily explainable to any jury. That this is a ridiculous matter. What's going on right here? I mean, he's actually schooling a judge and an attorney. Now, like I said, I don't think these are stupid people, the judge and the attorney. I think this is just this is a cabal. This is the legal society cabal, basically, where the judge and the attorney are in cahoots with each other, and Brad's not playing the good monkey. Brad won't be a good little monkey and follow and dance along to their music. Brad won't follow the song. Brad don't want to follow the song. Brad's going to just follow the law. And when he started doing that, they're all twisted up now. They don't know what to do.
But who's the injured party?
One moment, Mr. Morgan. We're just going to let me 1 second.
1 minute, Mr. Carrigan. You're making too much sense. You're killing us over here. Please shut up.
Have any information about how we can set a date for Mr. Carrigan?
Just message BMO. They're just checking right now.
But I think give him sufficient time if he wants to make some additional applications. But while we're trying to find some available dates for Mr. Carrigan to choose from,
This is when you start. They're bonded in.
What's that, Richard?
Yeah, Richard hit it right there. He said it basically. This is where Brad could have said, "Hey, wait a minute. We're not doing anything till I see this woman's bond." Listen, every hearing's got to be bonded. Okay, let me say, it's supposed to be bonded. Okay, and if they don't have a special bond for the hearing, well, then you're going to go tap the attorney's bond. But every hearing has to have a bond attached to it, and usually I think they generally use the attorney's bond to cover the hearing. Well, listen, he has every right to ask for her bond because he could state, listen, this woman's causing damage and harm to me. I need to know she could pay the damages because I'm going to have to file actions against her. I need to know that she's covered. She can cover this. Because basically she's getting in a car driving around like a maniac and we don't know she's got insurance. Well, that's what she's doing here. She's in court acting like a maniac. She's got no jurisdiction, no standing, and no personal knowledge in this matter. Yet she's making all these crazy claims, and she's changing dates on tickets. She's altering, forging, and fraud evidence. She's creating fraudulent evidence, and so I need to know she's got a bond because these are some serious crimes she's committing.
Objection, I demand you dismiss this case for lack of evidence and subject matter and personal jurisdiction.
100%. When you're asking them if they're bonded.
It would appear that the full information was provided to the Crown have in the way of officer's notes.
Information.
And then there were some pictures taken. The allegation is that these tickets arose out of a protest that Mr. Kerrigan was involved in.
Brad, you're a criminal, man. You went to a protest. Oh man, they should crucify you. You went to a protest. You major criminal, you.
So that's being provided. And then in the second file, information ending 452, that's where we have the body cam video. So we provided the disclosure that we have on file.
So let me get this straight. You got the body cam footage of Brad at a protest. Does that body cam footage show Brad injuring the crown? Is there like a gold crown that Brad like took a hammer and smacked it and bent it? I mean, what's the body cam footage have to do with any relevant thing in this matter? They don't even have it. They don't even have an injured party. The body cam footage is worthless.
Which again consists of notes, reports. I'm just looking for the file right now. Reports, prosecutor cover sheet, synopsis, officer statements that he picks up. And I can advise that he was issued a couple of tickets under the Traffic Safety Act. If that assists in the courts.
More things that she doesn't have personal knowledge of. This is just disgusting.
But that, of course, are not my responsibility. I'm just prosecuting the public.
They're not your responsibility, and what the hell are you bringing them up for? You have no personal knowledge of any of those tickets.
Health Act matters. And so, yeah, all of the documents that we have on file were provided, but the body wear camera was not provided because he would not accept that disclosure.
All right, and just again, if you're not providing what information, the traffic safety.
No, she's referencing. It sounded like she referenced two tickets that she didn't have any even involved in this matter, and she sort of. I think she stated that it's not her matter. It almost sounds like she's getting a rear end kicked left and right, and it's almost like trying to throw something else in. Like, well, let me throw some more dirt on him, you know? Well, gee, why don't we go back to Brad's childhood and find out something he did? You know, she just sounds like she's trying to pile stuff up here. It sounds like she just mentioned another ticket, some traffic tickets or citations or something that are not related to this matter, but she had to mention them. Why on earth would she do that?
Safety Act matters and two Public Health Act matters, right?
Your Honor, I object to the way that this is going right now. You've muted me. I'm not allowed to object, and you're making. Hello?
Yes. So is that you that you two crowns there that day?
I'm not sure. I don't think that's a little cumbersome, but at this point, I'm not sure what's going to be happening with the traffic matters. I can advise that I will be dealing with the public health matters.
And that even the public health matters, that's phony and fraudulent too. Who's the public? Is Mr. and Mrs. Public coming in to testify to explain how Brad injured him by going to a protest? I need Mr. and Mrs. Public in here to testify on how Mr. and Mrs. Public was injured by something that Brad did. This is all statutory nonsense, all junk.
Advised by whom?
Whether the Traffic Safety Act matters proceed or not, I can't speak to that at this point.
Can't speak at all.
Can't speak at all, yeah. They just keep muting me.
And other than the
Yeah, objection, violation of due process.
additional disclosure?
Yes, Your Honor. Yes?
Go ahead.
So he sent a. He spent.
Look at the silence gaps that are going on. They're lost. They have no direction. They don't know what to do with them right now.
Correspondence. He wants original copies of all tickets. He wants a copy of the warrant used for the arrest, all radio communication, all electronic communication, all video and audio recordings.
Ooh, and that's a good one I forgot. They better have an arrest warrant. The way these guys are operating, I'm going to guess they probably don't have an arrest warrant. They might, but the way they're operating right now, listen, you got to have an arrest warrant. Somebody's got to sign an arrest warrant for the arrest. explaining what happened, and they have personal knowledge of what happened, and they have to verify it. And listen, a lot of these are warrantless arrests. They just do things without a warrant. And listen, a cop can only interact with you in two ways. He's got to have a signed warrant from a judge, and that warrant can only be created by under oath or affirmation of an affiant that's stating that you committed a crime or you're about to commit a crime. And then they would take that oath or affirmation to a judge, and the judge would look at it and read it and determine whether it was valid, and he would sign a warrant for your arrest. That would go to the officer, and they would come pick you up. Okay, so they can only interact in two ways. One's the warrant that we just described. The other way is they need probable cause, and that's what Brad was mentioning in there. That what's the probable cause? Because we know that they weren't at this protest and had a warrant for Brad's arrest. That I know they didn't have that. So the only other way they could interact with Brad is through probable cause. We talk about probable cause. It's not a code violation, and I guarantee what they're charging Brad here with, without knowing anything about the code on the ticket, it's a code infraction. They're trying to call it a crime. I think it's called mala prohibita, which means a crime on paper only. So they're trying to claim that Brad broke one of their codes and that was a crime. Well, sorry, that's not a crime. That's a code infraction. So in order for them to interact with Brad, they need probable cause. Probable cause would have been if Brad turned around and punched somebody in the head and they seen it. That's a crime. Then they have probable cause. Then they could arrest Brad. Brad being in a protest that they didn't want him to be in, or for whatever reason, that's not a crime. Okay, so they didn't have the warrant, and now they don't have probable cause. So the question also is, how did this arrest occur? Because there better be a warrant attached to this arrest explaining what the probable cause was for the arrest. That's the purpose of the arrest warrant.
Full copy of a detention log and custody record with an appendix of who has accessed it, a copy of an electronic passbook, who had access and provided that the record complies with the legislation. So those are
where is she getting that you refused the disclosure of the video, Brad?
So, again, we've tried to provide the
She's saying that because I refused, they sent it on a USB stick, and I don't want a government USB stick into my computer.
Right.
Items that he has asked for that he's not received. It's the Crown's position that we will not be providing that by way of disclosure.
I didn't know that. That's really smart, actually. Yeah, I wouldn't want one of their USB sticks in my computer either. You know, I don't trust these people.
Ask them for a government laptop.
Yeah. Is that USB stick evidence of you violating anything?
How is a body camera evidence?
So this is the exact same issue that.
So am I able to speak, or am I just here to listen to you two decisions?
Dealing with. And so I think that.
Yeah, you got the judge. What's going on here? The judge is litigating on behalf of the prosecutor, and they're leaving Brad out of it. You know, they're muting him, and so you got the judge practicing law from the bench. She's litigating this case for the prosecutor. Judges are not supposed to do that. Judges are supposed to make decisions based on the law and based on the facts that were presented to the court. This judge isn't based on, not looking at any facts. She's over there litigating the case to help the prosecution.
We got to post this. I should be able to go on YouTube. What a fraud Canadian court system is.
Dude, send us
I was wondering about that earlier. But it's like a personal thing, so.
Brad, you got your wish.
But it's certainly worth it.
I don't want it.
Well, you could, if the courts were open, you could sit in on this, so it's not secret.
I'm recording it. I just missed the first like 10 seconds.
On the state information as the public health related matters. So, is there going to be a separate crown there, or how are you going to?
They just mute me. It's just insanity. But I come in again and I start beating her up a bit.
He said they muted him. Look at all that talking's going on. You got the judge litigating for the prosecutor. They're having this long conversation. He can't even object right here because they got him muted. Brad, don't go back to this court, please.
Those could be severed and sent to traffic court, or a resident could assume conduct of them. So either it could be severed and the traffic matters could go to traffic court.
Well, Brad, it technically is being recorded because we are all being recorded right now, and it'll be up on BitChute.
They're trying to separate the case right now. Listen to them talking.
Because they're lost.
Could you back it up just a little bit? I talked through it. I'm sorry.
Yeah, go ahead and back it up a little bit, but they're trying to split the what was it, the health thing and the traffic matter.
Yeah.
Okay, here.
Because they're going to try to bring it in under another thing. I know they'll dismiss one probably and bring it, try to bring it in. They're sneaky.
Again, we tried to provide the video. We provided everything that we have on the file and that we will be providing. So those items that he has asked for that he's not received, it's the Crown's position that
Objection. It's the Crown's position. Who's the Crown? Are you the Crown? Because who's the Crown? How does a corporate fiction, a fictional entity, have a position? It can't. It doesn't have a position. You, the pettifogger shyster attorney, you have the position, and I can't even get your name from you.
we will not be providing that by way of disclosure.
And if Mr. Harrigan wants that, he is free, like everybody, any other accused, where there's a dispute about disclosure, to bring an application to have a judge decide whether or not that.
So I have to pay money to get evidence against me.
That's right, Your Honor. That's the Crown's position.
That's
They're
reasonable.
supposed to share the evidence.
And again, it was put over.
See that application process the judge's talking about? He's going to do an application to get evidence. That's all statutory bullcrap. Okay? That's under their rules of civil procedure. No, you're entitled to see the evidence from the other side. I don't need to go through your application process. Give me the damn evidence.
So this is the exact same issue that the
So am I able to speak, or am I just here to listen to you two make decisions?
dealing with.
Did they hear that?
No,
You
I'm muted.
Are you able to speak, Brad? What does the king do?
No, I'm muted. This is all muted. I'm muted. They're just making their decisions.
I'm enraged and it's not even my court. Holy man.
Mr. Harrigan is asking for various,
Mr. Kerrigan.
Mr. Kerrigan's asking for various things. Mr. Kerrigan's asking for evidence, which you guys don't have.
You were Bradley.
We got to put this on lock for freedom. Let them people listen to what a sham this court hearing is.
You were Bradley in the beginning, and you're Mr. Kerrigan
Slow
now.
down, they're saying educate him now.
on the same information as the public health related matters. So, is there going to be a separate crown there, or how are you going to sever those, or how's that going?
Nobody knows what's going on. Is there going to be a separate crown there? Oh, there's two crowns? You know? Oh, there's not just one crown, there's two crowns? Is there going to be a separate crown there? This is a ridiculous process. This is the definition of a kangaroo court.
I don't know the specific answer to that, but those could be severed and sent to traffic court, or a resident could assume conduct of them. So either it could be severed and the traffic matters could go to traffic court where a traffic prosecutor would prosecute them, or my friend could assume conduct of them.
Severed.
Should let him do it.
Nothing further yet from in terms of trial dates, Madam Clerk?
You know, I'm just asking if there was to be a pre-trial conference date, or if you'd like us to just go straight to trial.
Well, I think we're going to need pre-trial conferences if we're. I think maybe we probably should get pre-trial conferences.
This is like two idiots. You know, one idiot doesn't know what the other idiot's doing. They're two idiots congregating, talking to each other. This is really bad.
Val, that's what they're talking about.
But I do think, given the charges and Mr. Kerrigan's position. Now, I'll hear from Mr. Kerrigan again.
Oh, thank you.
Regarding. I want to make sure he understands that if he wants more disclosure, he can bring an application. You understand that, Mr. Kerrigan?
I do
He's got to do an application to get disclosure. Come on.
not stand under. I would like to explain a few things to you that on record. So there's no evidence by this attorney. They're submitting motions. You're agreeing with these motions. A witness must have personal knowledge. I've asked for the tickets. I'm not given the tickets. That's the only personal knowledge there is. She's got videos. That's not personal knowledge. That's somebody taking video. If they want to come to the court, that's fine. So I'm asking what probable cause there is. And are you stating that I am your property under this matter? Because if you are, I do not consent. And I want to make that very clear. So are you stating I'm your property? Okay, so I'm not your property. Perfect. So we understand that that you understand then that I'm not your property. So to make judgments, I have to either be your property or there has to be evidence of a wrongdoing. Now, I've asked specifically, and I'm not trying to be hard to get along with, I just want these tickets so I can see them for myself. Right now, it's hearsay that there were tickets. Now, if the Crown is bringing this action against me, why is it so difficult after 3 notices in writing for the Crown to provide, if they're representing somebody who said I've done harm, to show the harm that I've done in the aspect of a ticket? Why is that a problem? Where are the tickets that were issued? Why were they not given to me? Why can I not see the officer's name
read the
and the
numbers
time
out
and the
of
date
them.
instead of her now trying to get you to change the dates, which is unlawful?
Wow.
To come onto the court scene and then try to change the dates without my consent. I don't consent to that. I object strongly to that, Your Honor. You can't just change a date because that's her evidence. She's saying in her evidence that it was the 20th. Now all of a sudden she says, well, oh no, that evidence doesn't work. Now it's the 26th.
Man, that is, you're talking fraud and forgery right there. They're tampering with evidence. They're changing the records.
And I'm saying, well, where is the ticket that shows the date of the infraction, the alleged
Quoted the ticket
infraction?
number.
Where is it?
Earlier on.
And why? No, I'm talking right now. You just hold on, please. You don't. I'm speaking. Excuse me. I'm speaking. It goes both
Hell
ways,
yeah,
Your
Brad.
Honor. You can't have her interrupt me. I listened for 5 minutes while she just spoke to you. Now I have that same right. And I appreciate that she doesn't interrupt anymore. She's misleading you. And I don't
they
appreciate it.
muted you.
She doesn't have the evidence. I don't want paper that she writes out that she can change dates and decide how the court case will look. It has to be factual and to the foundation of truth. And it's not that way right now. She's misrepresenting the truth. She has no jurisdiction. She has no firsthand knowledge, but she's changing dates. It's ridiculous. Where is the tickets that came with the infractions? I want to see the ticket.
Now listen, here's why they don't want to give him the tickets, because the tickets got the wrong dates on them. This is why they don't want to hand the tickets over. I mean, think about what's going on here. This whole thing, this whole little hearing's been about her changing the dates on these tickets. If they give him the original tickets, he's got the original dates on there. And then, because that's not going to work, because if Brad gets the original dates, their whole case falls apart. So the prosecutor had to get into this little hearing to get this corrupt judge to change the dates on the tickets. And this is why they don't want to give Brad the original tickets, because the changed dates are going to be different than what's on the original ticket. And that's going to be evidence of fraud and forgery. They're crimes. These are crimes. You witnessed crimes right here, what they just did. They're changing dates on things. This is why Brad can't get his tickets, because the dates are wrong on the original tickets. And they can't win with that wrong date. So they got to try and do this little kangaroo court process to get the judge to change the date. But they don't want to give Brad those tickets, because then you got 2 conflicting dates. And gee, the one they changed, that's evidence of forgery and fraud.
Period. That's all I want to see. Where are they? And if they can't provide it,
Move for
you know, there's
dismissal.
there's no probable cause for a criminal case. So what are we doing here? You know, it's just ridiculous. The least, every ticket ever given, you have a right to look at the ticket and respond to the ticket. I was never given that ticket. So, you know, so I don't consent to the way this hearing is going right now. I've asked if you've received the affidavit, and now she's speaking to my affidavit like she has firsthand knowledge.
Times that you want the ticket, there is no ticket from what my understanding is.
There has to be.
If your case is as strong as you think it is, you'll.
No. She has the burden of proof.
That's a trial.
She has the burden of proof. Why do I have to go to trial if there's no burden of proof? What, she can just say there's a ticket?
They don't find me in any
Good.
way. All I'm trying to do is move the trial along. That's what the
Well, I understand that you're in a hard position, but you also have a responsibility.
proper evidence. I haven't heard any evidence, not from you, not from the Crown.
Bull, he's got his affidavit right there, affidavit of status. He's got it on the record. If he filed any other affidavit, his affidavit's on the record. That judge just lied.
So right now we're waiting to hear some trial dates and some pre-trial conference dates. If you need more the issue of tickets, for example.
She just admitted there was no evidence.
Why should I, excuse me, Your Honor, why, here, just hear me out, please. Why should I take on an expense of a lawyer and have to go to court?
Express his frustration about the absence of tickets and about the changing of the date. In the meantime, we're still waiting for the clerks to get some feedback on possible trial dates. And I'd like to ask the Crown regarding
Trial of what?
You got, look, this is ridiculous. There's no evidence of anything, and they're going to set a trial date. Are you kidding me?
I received information from the clerk at CMO with trial dates.
And just to confirm that those are going to work for the Crown, they are.
CMO is Crown Magistrate's Office.
Ah, thank you.
They've just given me one date for
Well, that,
each matter, and they've also given me a piece.
give me a break.
And then they also give me a
Well, you know, Your Honor, you're not even letting me speak now to this. You're making choices without me being online here.
I'm going to let Mr. Kerrigan know. Mr. Kerrigan?
Oh, hi.
Bradley.
Again, I object to her just randomly picking dates and saying these are the dates. You
Oh, hi.
in line with what she wants and what the Calgary police services want. There's, you know, I have a life too. I have a right to pick, you know, if you're going to push this along, you know, with my objection, then I still have a right to help in the process of deciding what dates are available to me and what's, you know, what makes sense, right? So again, I don't see any injured party in this action. There is no cause of action. And without an injured party, there's no probable cause under the criminal code. So when she's bringing this forward, and I'm asking very politely to show me the tickets, and she says there are no tickets, then there's no violation of anything. Because these officers have to write tickets for a violation. And if there's no violation and there's no ticket, then there's no cause. A video, isn't probable cause. A video doesn't do anything. There has to be a violation ticket given out. And that was not done. And if it was done, where are the tickets? So why are we here wasting our time? And if she's not going to provide the tickets, Your Honor, why would I have to go get a lawyer to get evidence against me? Why am I supposed to go out and get a ticket and then go and hire a lawyer, go into court, get a hearing, to go in front of a judge to get them to produce a ticket when there is no claim against me that's valid at this point? That's all I'm saying. So to move this forward, if we're going to talk dates, then I want a list of 4 or 5 dates that I can choose from that make sense to my scheduling and my business and everything that I'm involved in. And if I have to speak to anyone to help on this process. So I need the same courtesy and respect. I'm not going to be railroaded through this system. So I hope, again, I've stated on record, that, I've got an affidavit that you're refusing to hold and witness and bring into the court record at this point. I don't know why, but the Crown has been able to quote from it, and she says she never received it. And she's stating firsthand knowledge of things, and she's not under oath. And, it's ridiculous. Anyway, so being the beneficiary.
Kerrigan, on mute again. I'll just explain to him where we stand. Mr. Kerrigan, I just want to make clear a couple of things. First of all, Crown has your this affidavit that you referred to. It has not made its way onto the court file. I only have the court file.
Why is that?
You talk about a registrar. There's no such thing as a registrar for the court, so I'm not sure where you filed it, but it's not on the court file. That's number one. Number two, the Crown did not.
So his affidavit's not on the court record. That's their problem. That's not his. Go find it. Go get it. So you people had a hearing. You weren't even prepared.
The Crown received what's called a scheduling notice that told them the dates that were chosen based on the availability of the officers who will be testifying.
It's the availability of the officers. We're worried about the officers, not Brad. Come on, man.
Court time that's available, not my time. I'm not going to be the trial judge. Basically, there's a lot of courtrooms and a lot of people who need courtrooms. So far we have 2 trial dates, and if you want an adjournment, or if you want to bring an application regarding further evidence or for better disclosure, you have a right to apply for that. We're not taking away any of your rights, but we're just assuring that this matter moves on. There will be.
We're just ensuring this matter moves on. You got a party over here with no evidence. And he's right. Listen. The burden of proof's on the party bringing the claim. It's not on Brad. Brad doesn't have to prove anything. The burden of proof's on the attorney, the prosecutor. So we already know Brad's got evidence on the record with his affidavit. Okay. Well, maybe that's why his affidavit's not on the court's record there. She said they don't have it, but the prosecutor admitted that she had it after she said she didn't. So that's why they don't want that affidavit on the record, because this judge wants to say, well, there's no evidence in this matter. Well, then guess what? You shouldn't be there's no more hearings then. Okay. In other words, there's not even prima facie evidence. Prima facie means on the face of it. This looks like it could be true. There's not even prima facie evidence in this matter that Brad did anything to anybody. And the judge actually admitted there's no evidence on the record, even though she was wrong. Brad's got evidence on the record, but she just stated by her statement there that the Crown, the fictional entity being moved by the prosecutor, doesn't have evidence on the record. So let me get this straight. Objection, Miss Judge. You're going to schedule a hearing when you just admitted that the prosecutor has no evidence in this matter? How's that work? Miss, where's the prima facie evidence? Where on the face is prima facie evidence? Because guess what the prima facie evidence would have been in this matter? It would have been the 2 tickets that they don't want to give to Brad, because they don't want to give them tickets to Brad because they got the wrong dates on them. And this case ends with those wrong dates. So these scumbags figured they're going to run into court, and they're not going to give them the tickets, and they're giving them a runaround on why they can't give them the tickets. And Brad evidently sounds like he's seen the guys write the tickets. So there's tickets, but they're trying to claim they can't give them the tickets, and it's some bogus reason they gave them. And the reason they can't give them the tickets is because they just altered them. They forged them, and that's forgery and fraud, what they just did, by changing the dates on those tickets. That's why Brad doesn't have his tickets. And yet there's no evidence. In other words, those tickets were the prima facie evidence to move forward. Well, now they don't even have prima facie evidence. They got 0 evidence. And this judge is going to schedule a hearing? That's a crime.
A trial, first of all, on the public, on information. Let me just make sure I get the information number right. On information ending 452. So that's the information where you have some Traffic Safety Act matters combined with 2 Public Health Act matters relating to some sort of Public Health Act supposed offenses that supposedly you agree to these things.
Can you hear me right now?
I will be held in September.
Are you able to hear me?
At
Hello?
No, they got him muted again. So the judge is over there litigating this case, And Brad's muted. He can't even object to what's going on.
Are you able to hear what I'm saying?
9 a.m. for half a day. You set that up at 10:05. 9 a.m. at the courthouse, 10:05, September 10th.
Talking to himself.
And the other one, there's another one that's supposed to do with the elected November. Supposedly, again, you breached this order. Supposedly you weren't wearing a mask, where it was the law that you had to wear a mask.
I don't know. I haven't seen anything.
That's not a law.
June 11th, 2021. So that's about 2 months from now. And again, you can apply for adjournment if you're not ready to go. You can bring an application in advance. You need more information regarding.
Don't use any of their applications. Don't petition them for nothing. Don't use their applications. Bang them with affidavits. You demand stuff through affidavits. Don't go through their process. And do what Christopher James has done with the cases he's gotten there. Basically, take out the rules of civil procedure. When you file the if you're supposed to file an application for something, take out on that document. Take out the rules of civil procedure. Basically, state that those rules are for the members of the legal society. You're not a member of the legal society. Those rules have nothing to do with you, and they can't determine how you access an open court or how you get records in an open public court. So bang the rules of civil procedure out, and then ask for your documents by way of affidavit.
Regarding disclosure or anything that you disagree with, I'm going to ask the clerks to see that these scheduling notices get mailed to this Village Lane, Okotoka address. Make sure you get that. And I don't think there's anything else we have to do right here and now. I just want to make sure those get mailed to Mr. Kerrigan. Those two
Bradley.
notices.
So am I not able to speak?
There's nothing further, Mr. Kerrigan. We will move on. We have lots of matters still to deal with. We've spent more
Tells
time
you there's nothing.
than any other matter.
It's good right now. Hold on.
So hello? Am I able to speak now, or am I still muted?
Yes, no, you can.
So I am able to speak. So what was your name again? I'm sorry, Judge. What was your Justice? Was it Judge or Justice?
My name is Judge Schreier, S-H-R.
S-H-R, yeah.
I-A-R.
I-A-R. And who's the Crown that's here today, please? Their names?
The Crown's name is
I'm sorry? How do you spell Karen? K-A...
I'm not sure, sir.
Well, can I go on record so I know who I'm speaking with and who's on the other side? Both the parties that spoke, I would like their names, please. Just for the record.
I will decline from that. Thank you.
So you're going and making evidential...
Oh my God, she declined to give her name. Oh.
Evidence against me in this hearing, and you're not willing to state your name? Are you kidding me? Is that what you're doing? You're not willing to put your name beside the evidence that you want to change dates on the tickets, and you're not willing to give your name as someone who's provided evidence to this court? Are you kidding me?
Okay, Mr. Kerrigan, I have been on mute while I ask the Crown to state her name for the record.
Please.
And I appreciate.
And her assistant or whoever else was on file, please.
No, I'll ask the Crown will state her name, and then we will adjourn your matter.
Absolutely not.
Yes, Karen Thorsford. Thank you, Mr. Kerrigan, I wish you a good day. And
There was another lady who spoke. Can you please put her on record? I want to know who that is as well, please.
We're not going to name the clerk.
That was a clerk. My apologies. So I just wanted to mention, Your Honor.
But he could have got the clerk's name. I would have demanded the clerk's name too. Anyone involved in this kangaroo court process, I want their names.
Quickly. Now, Form CC1 was submitted with the court number under the provincial. It was the filing. That was how it was sent into the court. And that was the way that the registrar had said it, because you said there's no registrar. Well, the clerk that was doing the filing, it was under the Form CC1, Sub-Rule 5.1 and Rule 14. And it was filed under a provincial court of Alberta.
That was just
so that was filed.
I'm going to take my leave of the court. Good day.
Your Honor. So what were the dates? What were the dates that I'm supposed to appear?
11.
I'm sorry, you're breaking up a little bit.
June 11th, 2021.
Brad, let them mail you the documents, and I'm pretty sure you guys have mail fraud over there also. Go file mail fraud claim against them.
9 a.m.
June 11th?
That's the 6th month of the year. June, after May and before July. June
I was just
11th,
messing with them.
1,
Yeah.
21.
Let me see. Oh, what
And
was
at
that again?
9:00, that's in the morning at the courthouse?
It's at 2:30 in court, 5:30. I apologize. 2:30, courtroom 506.
2:30, courtroom. .506. And now, is that a provincial court?
Yes, sir. And the other one will be held on September the 10th.
Which one are we talking? Which one is which, please? So June
And what's
11th
the
is what?
purpose?
What is that about? What's that for?
That's the 2-count information regarding allegations that occurred in November.
Your Honor, that's the June 11th date is the pre-trial conference. That's for both information and the trial date.
You don't have a trial on the other one?
The trial date on the other one is for
I mean, it's like Mutt and Jeff to communicate with each other. This whole thing's ridiculous.
at 1:30 in court 10:05.
They can't even get the court dates right.
Okay, so it's getting confusing. I just want to make sure I'm clear so that we don't have more misunderstandings.
Mr. Carrigan, I confused you. It's my fault.
No, it's all right. Life goes on.
Let's play that again.
Life goes on. Let's try again. So I've got September 10th at 9:05 in the morning. What is that about?
September 10 at 9:05 will be a trial on information ending. That will be an trial on information ending 5-2.
I'm sorry? Trial about what? What's the trial for?
Information.
On the information that
Yeah, I would like it quoted to me so I know what we're talking about, please.
Trial?
So it's
You don't
trial
know.
information in the what trial
You don't
information
know.
for
What
what? What is
information?
the case about?
I have to have a trial for my rights?
Well, I won't, but they're just numbers. What is the case about? Do you know? Or is it just numbers?
it will be on information ending 2013.
What is that?
452. And that has to do with conduct alleged in December 2020.
Which conduct? What conduct?
That's for trial. On the other one,
So is that a trial date or is that a
The
preliminary
other
hearing?
one,
no, that's a trial date for that information.
Hmm. And June 11th is which?
And I'm going to give this one back to Madam Clerk.
Oh man, this is
did you
painful.
say she was a registrar too, Brad?
No,
And that has to do with
the
this
court
one. I'm going to tell you.
registrar.
That has to do with conduct in November of 2020, alleged. You didn't wear a mask and you participated.
Excuse me, sorry to interrupt, but are these, so the trial date information ending 2013-40452, is that not the same, aren't they all about the same thing, the masks and the bylaw infraction? So why are they on different dates?
No, they severed them.
They should be on the same date. Why should I go to trial 2 times for 2 different tickets? Isn't that a little, when they're the same tickets?
Okay, Mr. Carrigan, we're going to put you on mute, but I'm going to say it one more time. The one I just read into the record has to do with conduct that supposedly the Crown says, they have to prove it, it's not proven. The Crown says it occurred in December of 2020, so last year in December. That's the trial that's going to be held in that I just read to you.
And guess what? All Brad's got to do to make this go away, go file bar grievances against that prosecutor and her assistant, and go file a judicial complaint against this judge. Because my God, I could write pages of a judicial complaint on this judge. If he files against the judge, a judicial complaint, and if a lot of judges keep their bar numbers also, and if she's kept her bar number, go file bar grievance against her too. Go ring the insurance bell twice, and then file one against the prosecutor. That'll ring her insurance bell, and go file against her assistant there. That'll ring that individual's insurance bell. And after he does that, then he can move on to filing a notice of claim for damages against these people, supported by affidavits. And when he files that notice of claim, and it's got to, I would say, make it a substantial amount of money you request, because I just witnessed multiple crimes here. When he files that notice of claim, it's got a financial component on it. That attorney and the assistant, if she's got a bar number, they're going to have to contact the insurance company that insures them, their indemnity insurer, and tell them they've also had a claim filed against them. And the insurance company's going to know what's the claim about and what's the amount. And if Brad makes it substantial, the insurance company's not going to be very happy with this attorney and the assistant's attorney, because I don't know how much these fines are for. But gee, man, Brad can go out there, $500,000 against the prosecutor and $500,000 against the assistant. We're talking about like $1 million there, and he could do it against the judge too, $500,000 for her. She's talking about like $1.5 million versus whatever the fines they were going to try to get out of them. And this is how things sort of go away with bar grievances. This is why we file bar grievances, because we're dinging their insurance.
On September the 10th. Okay? The other one, now I'm going to do that one now, is information ending 2013084 67P1. That has to do with conduct that supposedly, not proven, but that Crown says, and they have to prove it, supposedly occurred in November, a month prior approximately.
Listen, before they could have a scheduled trial, there's got to be prima facie evidence, which means on its face, they have to make some kind of evidence they've got to put before the court that shows on its face what they're claiming is probably true. There's no prima facie evidence here, and yet she's over there scheduling hearings. These are crimes.
Again, to do with masking and public gathering. But that one will be held, there's going to be 2 hearings on that one. That one is being held, the trial is being held at September the 3rd, so a week earlier, September the 3rd at 1:30. Not at 9 o'clock, but 1:30, September 3rd. But that one will also have what's called a pre-trial conference. You can talk about outstanding disclosure or information that you need, or whether you're ready to go, or how you want to proceed. You're going to have another opportunity to bring forward some preliminary matters. And that one will be June 11th. That preliminary matter or preliminary discussion will be on June 11th, 2021, at 2:30 p.m.
Now, see, if this is me over here, I would say to the judge, listen, I'm going to need you to mail them to me so I could file mail fraud complaints against every document you send me. I'm going to need them you got to send them by mail. I'm not writing this stuff down. I need you to send that to me through the mail so I can file mail fraud complaints against you.
So that one has two dates. One for another court hearing where you can talk about outstanding matters, and then the actual trial date.
You can't do these things by the telephone.
No.
So one has to do with conduct in November, one has to do with conduct in December.
Yeah, but the Crown should put them both onto one hearing so we don't waste time, because it's all going to be the same argument. Why would I have to go to court 2 different times and 2 different hearings for the same matter? They're basically the same. They're basically the same matter. Why are we splitting the dates? It doesn't make sense. They should be combined. They should be one hearing for the matter of the masks.
Here's why they're splitting the dates. Now we know they're playing games with the tickets. That the original tickets got the wrong dates on them. Okay, we know that, and they just modified the dates, so they just falsified the dates. The reason they split it, because if they have to drop the matter where they're falsifying the documents, the tickets, they're hoping to have the other matter that they can move against them. If they had them on the same trial, they would lose because they got falsified documents. And not only should they lose because they have falsified documents, they should go to jail for what they're doing right here. But this is why they've split these dates on Brad here. They know they know he's on to them changing dates. That what's going to happen probably is they're just going to abandon that case because that's treacherous, that case for them. So they're going to probably wind up abandoning that. So they want the other whatever traffic citation thing. They want it separated so that they could still try and extort money from them in the traffic citation thing. But that's why they've split the dates.
And if they're saying that allegedly that I did something wrong and they can prove it, then show it can all be done in one day. Why are we having 5 different hearings, 3 different hearings, 3 different court dates for this? Seems
That's a rhetorical question, is it, Brad?
To say that. Yeah. So
I mean, we know why they want to do that. It's like more money, more feeding the beast.
No, it's not about the money really. They're worried about the dates are all on the ticket. And if that's all in one, if those matters were joined together in just one case, one trial, they're going to lose because the tickets, he don't have the original tickets. They don't have the original charging instrument. And not only does he not have the original charging instrument, they've falsified and forged the other document. They changed dates on it. So they would lose all the matters at that point and also be subject to crimes. But that's why they, like I said, again, that's why they did that. They falsified the dates on the one, and they tried to separate them out.
You can follow up on June 11th, because June 11th is not a trial date. You can ask for them all to be joined on that date. That date will be a good date for you to bring in all of your matters to discuss with the court. Another hearing, an opportunity for you to discuss readiness for
what
trial
was
and
today?
preliminary steps that have to be taken.
right.
Ready to go.
And so the June 11th. Sorry, I know you want to get on with your day. But June 11th. So you're saying June 11th. At what was the time? June 11th then? Because I'm confused. There's September, 2 Septembers now. There's a June as well. So
What the hell was that?
What was that? Like the end of a commercial?
They hung up.
Yeah, that's it. He hung up on
Wow. So it ended up just like that's how it ended.
That's how
Insane.
I just
Wow.
want to say,
Wow, that was, like I said, Tammy sent this to me, and I just heard the first couple minutes. And listen, I didn't like hear this whole thing through. I did this all on the fly because once I heard the first few minutes, I'm like, this whole thing's ridiculous. I knew it was gonna be a ridiculous hearing. I just didn't know how ridiculous it was going to get. But so what you just witnessed there was judge committed numerous crimes. The prosecutor committed crimes. The assistant prosecutor committed crimes. The clerk committed crimes in that court that for scheduling this stuff committed crimes. You witnessed them falsifying and forging documents. We know they have the wrong date on the original ticket, so they had to falsify it. Hence why they separated the two matters. And when Brad was saying, why can't we just do this all together? Well, they don't want to do it together because they know what's going to happen is they're probably going to let the one go, and they're going to let the one go. But what I recommend with Brad before he moves into I don't think he's ever going to make it to these trial here, these kangaroo court trials. Judicial complaint and bar grievance against the judge, bar grievance against the prosecutor, bar grievance against her assistant, and then I start moving basically notice of claims supported by affidavits against them, and that notice of claims is going to have an extreme financial component to it. And here's what's going to happen: the bar grievance, when you file that, you're going to get a nice letter back from the bar saying that your claims are vexatious and frivolous. Don't worry about that. That's just a standard letter they send out to sort of discourage you to file complaints against them in the future. Okay, that's all that letter is. So what you're going to do, what you don't know is, when you file that bar grievance against that attorney, that's going to ring the insurance bell. Okay, most likely the rates are going to go up for that attorney. Now, when you file that, you do the same thing against the assistant prosecutor and the judge. Then you follow it up with a notice of claim. And if I were Brad, I would ask for substantial amounts of money for what I just seen here. That's a notice of claim, and you're going to support it with your affidavit of status and your affidavit of fact. And his affidavit of fact is going to be hilarious because he's got crime after crime here he could state in that affidavit of fact. So he could serve that through certified or registered mail upon the judge, upon the prosecutor, upon the assistant prosecutor. Once he hits that matter right there, I just have a feeling that his paperwork's going to disappear, or this thing's going to disappear, and they're just going to make these go away. Because once they see the figures that he wants in that paperwork, I don't know how much his fines are. They can't be anything related close to like $1.5 million. So listen, the insurance company looks at them and they say, hey, listen, if you don't have this guy, you better have him. If you don't have this guy, he's going to thump you. He's going to thump the insurance company for the two attorneys there. They're each going to get banged for say I don't know what number he's going to pick, but they're going to get banged for $500,000 each insurance company. That insurance company is going to go, you better make sure you got this guy, because if you lose, we got to foot the bill. And if we have to foot the bill, we're going to drop your insurance, or we're going to send your rates through the sky. So yeah, I just wanted to do a little commentary like I did with Richard's video, because I think people learn a lot when they hear what's really going on. And this was a classic. I mean, this was stunning. So look what these people are doing. Like I said, he's not a trained attorney. He didn't go to school for law, and I'm sure he hasn't been doing this too long. And look what he did to a judge, to a prosecutor, and to an assistant prosecutor. He had him spinning in circles. And guess what? Brad's holding all the cards. They're not holding anything. And if they're not smart enough to figure this out, Brad can make it very painful for them to figure it out by extracting a lot of money out of them. But just wanted to do this one. Keep your heads up. Don't let these people get to you. You just witnessed how stupid these people really are. So, just stay with it. Just learn little bit by little bit, and take the stuff that Brad did here and add to what I just commented on, and refine it, and you'll be able to stand up to any of these people. All right, take care.